that. So the transfer of interest and the the MSAs are all my team.
So this is the,
Yes.
I was thinking, to be honest, like you should put the
You
note.
on a phone or Zoom?
Because you see areas of concern.
Okay, yeah, I'll pass that along.
Discipline. You were bad.
Good morning, everyone. We're going to go ahead and get started on our June 20th monthly meeting of the Cannabis Compliance Board. Can we call the meeting to order? Can we have a roll call, please?
Thank you, Chair. With the meeting now called to order, I will now take the roll. Dr. Mazarano.
Here.
Member Merritt. She's not here. Honorable Douglas.
Here.
Member Vice Chair Durrett.
Here.
And Chair Guzman Freilich.
Here.
Here we have a quorum.
Thank you very much. Now we will go on to item number 1 of our agenda, which is the public comment. I want to remind everybody that we have a limit of 3 minutes. We will go to the south, we'll go to the north, and then we'll also go online. But we do have a disclaimer with regard to the online process.
To provide public comment via telephone, call 669-444-9171. Enter webinar ID 879-0320-9953, followed by passcode 788812.
Thank you. All right, with that, we'll go ahead and have a public comment down in the south. Is there anybody who has public comment? Go ahead and come up to the front and identify yourself for the record. Our court reporter needs to have your full name.
Good morning.
You can have a
Melissa Waite with the law firm of Dickinson Wright.
good morning.
Good morning, Chairwoman, members of the board, Executive Director Hum. I'm here to present this morning on behalf of my client, Polaris REIT LLC. They're a lender and they're a third party with an interest in item 7A on your agenda today. That item is involving an order to show cause for Stride Wellness related to 2 of their licenses, C206, P131, as to why TOI number 24001 should not be rejected and or denied as incomplete. So my client recently, on May 30th, just last month, was involved in a settlement with one of the parties to that TOI, in which item 9 agreed to transfer whatever interest they have.
Did you want to hold your comments for that item? Because we will have that item.
Absolutely. If you'd like me to present on the item, I'm not a party. I'm not involved in the TOI. And so I just wanted to make sure that you knew I was here today. I'm going to stick around to observe the item. I'll be available to present if you have questions or if it comes up that you'd like to hear from me further. I'd absolutely be happy to chat and present to you again at that time if it's appropriate.
Okay, all right, then we'll hold off until that item. Thank you.
So much.
Any other public comment in the south? Okay, we'll go to the north. Is there any public comment in the north?
There's no comment in the north.
Okay, thank you. And we'll go online.
If you wish to provide public comment, dial *9 to raise your hand if joining by telephone, or click the raise hand icon if joining via Zoom. There's no online comment.
Okay, thank you. With that, we'll move on to item number 2, which is the approval of the meeting minutes. We've got 3 items under that, starting with item A, which is the consideration of approval of the May 16th, 2024 Cannabis Compliance Board meeting minutes. If we've had an opportunity to review the minutes, if you have any comments or concerns, this would be the time. If not, I'll go ahead and take a motion for the approval of the minutes of the board meeting of May 16th, 2024.
The record member Douglas, motion for approval of May 16th, 2024 Cannabis Compliance Board meeting.
Okay, thank you. We have a first. Is there a second?
Member Mazarano, seconds.
Perfect. We've got a second. Is there any discussion on the motion? Hearing none. All those in favor say aye. Aye. Any opposed? Motion carries. Item B is a consideration of acceptance of the April 30th, 2024 lab regulations workshop minutes. We've had an opportunity to review those minutes. And if there are no changes, then I'll take a motion.
Member Douglas, for the record, I note this is in a different, this is an acceptance as of the lab regulation workshop minute meetings from April 30th, 2020.
Thank you for that.
And with that, we are merely accepting those minutes. My motion is for,
We have a motion for acceptance. Is there a second?
Member Mazarano seconds that.
Okay, first and second, any discussion? Hearing none, all those in favor say aye. Aye.
aye.
Any opposed? Motion carries. We have another acceptance. This is of the May 14th, 2024 Disciplinary Regulations Workshop Minutes. Do I have a motion for that?
Again, for the record, Member Douglas, note that this is merely an acceptance of that May 14th, 2024 Disciplinary Regulation Workshop Minutes. This is a true and correct copy of that meeting for acceptance.
A second?
Member Mazarano seconds that.
Thank you. Any discussion on the motion? Hearing none, all those in favor say aye. Aye. Any opposed? No opposed? Okay, motion carries. Thank you. Okay, we have a consent agenda item. This is a consideration of approval to extend final inspection deadline for La Lounge LLC. And Mr. Gilbert, are you presenting on that?
Sure, I can present on that, Chair. Good morning, Chair and members of the board. Steve Gilbert, Chief of Administration for the record. Item 1 is for La Lounge LLC, which was approved for a conditional independent consumption lounge license in the Clark County jurisdiction after passing suitability by the board at the July 25th, 2023 meeting. On February 7th, 2024, through its legal counsel, La Lounge submitted a letter to the CCB requesting a one-year extension of the July 25th, 2024 deadline for final inspection, requesting it to July 25th, 2025. As the extension request did not go before the board prior to the June board meeting, and in preparation for the meeting, the CCB requested that La Lounge submit an updated letter and include any supporting documentation of its efforts. La Lounge reports it had identified 3 potential locations and had entered into negotiations with the landlords, but were unable to reach an agreement at any of those properties. Most recently, La Lounge found another potential property it was interested in leasing. It discovered a potential distance separation issue at the site in April 2024 and is continuing to investigate the distance issue. La Lounge reports it has done everything in its power to locate and secure a site, but due to extenuating circumstances, has not been able to do so. It is therefore requesting a one-year extension. I'm available for any questions, and Amanda Connor is present today to give a brief presentation or address any questions you may have.
Thank you. Ms. Connor, I'll wait for you to come up here and give any comments you might have.
Good morning,
Good morning.
Chairwoman, members of the board. Amanda Connor with the law firm of Connor & Connor on behalf of my client, La Lounge. Mr. Gilbert covered the request for extension of time. As the board has indicated in prior meetings, for these lounges, the independent lounges, securing a location is proving extraordinarily difficult. My client, even before receiving the conditional approval by the board, had already been identifying locations and in discussions with landlords. And some of these were ongoing, extensive for months. They would reach terms and then the landlord would be notified by their lenders of their mortgage that they could not enter into such lease.
Others, like Mr. Gilbert indicated, there's potential distance separation due to gaming or something else. So they are diligently searching, but have been unable to secure a location at this time. So we kindly request a 1-year extension of time.
Thank you. Does the board have any questions for either staff or Ms. Connor with regard to this item? Okay, with that, we'll bring it back to the board for consideration and approval to extend the final inspection deadline. We have a motion for approval.
Douglas, for the record, motion for approval of the 1-year extension or location, well, in this matter for licensing of the for the lounge, independent consumption lounge, noting that counsel and the client have shown due diligence thus far.
Thank you. We have a first. Is there a second?
Member Mazzarano seconds that motion.
Any discussion on the motion? All those in favor say aye.
Aye.
Aye. Any opposed? Motion carries. Thank you.
Thank you.
Okay, we're going on to item number 4 on our agenda. This is a consideration of a proposed settlement agreement to resolve disciplinary action. This is with regard to Cannabis Compliance Board versus 1212 LLC. Mr. Rath.
Good morning, Chair, Vice Chair, members of the board. L. Christopher Rath for the record, Senior Deputy Attorney General. I'll be presenting this agenda item, which is settlement agreement in the case of CCB versus 1212 LLC, CCB case number 2024-007. This licensee is a medical and adult use cannabis cultivation facility in Henderson. The complaint for this case was filed and served on April 26, 2024. After service of the complaint, counsel for the respondent, Mr. Adam Fulton, contacted me prior to the due date for the answer and requested that we engage in settlement discussions. We provided an extension to answer based on that and then proceeded with settlement discussions. We reached a settlement agreement in principle, so entered into a stipulation to stay to allow for the drafting of the settlement agreement and for the board to consider that settlement agreement, which is now before you. Briefly, the allegations of the complaint arise from a routine audit and investigation, which commenced in June 2023 and ran through October 2023. The key allegations of the complaint are that respondent 1 operated without all the required licenses and permits, 2 made an unintentional false statement or false misrepresentation of fact to the CCB agent, 3 failed to maintain required surveillance systems, 4 failed to follow seed to sale tracking requirements, 5 failed to meet the requirements for disposal of campus waste, 6 had an owner without a valid cannabis establishment owner agent card, 7 failed to submit timely inventory and sales reports, and 8 failed to properly maintain facility visitor logs. As noted in the complaint, several of these violations were repeat violations from their prior audit in June 2022, just about a year prior to the subject audit in 2023. As set forth in the proposed settlement agreement to resolve these matters, respondent admitted to the following 5 violations. 1 category 3 violation for failing to follow a required security plan. A 2nd category 3 violation for failing to comply with seed to sale tracking requirements. A category 4 violation for an owner failing to hold an agent card. A category 5 violation for failing to submit required reports to the board. And a 2nd category 5 violation for failing to maintain proper visitor logs. Respondent also agreed to pay a civil penalty in the amount of $35,000. That can either be paid within 30 days of approval of the settlement agreement or may be paid pursuant to a payment plan over 7 months with the first installment due on July 15 of 2024. The CCB staff and council fully considered mitigating factors in coming to this resolution. Those mitigating factors are outlined in paragraph 9 of the settlement agreement, and the parties have stipulated and agreed to the weighting of the mitigating factors. The mitigating factors include First, that respondent terminated the employee who was responsible for the false statement to the board, the lack of business license, and the security issues, and replaced this individual with a more qualified person. This factor was weighted the heaviest. Next is the fact that the respondent cooperated with CCB staff in coming to and implementing an appropriate plan of correction to prevent the violations at issue from occurring in the future. And third, respondent and its counsel cooperated with CCB counsel during the disciplinary process, and we were all able to come to a resolution quite quickly without the need to get an assignment to a hearing officer, have a hearing, and there was not even a need for an answer. Also, the CCB staff and the Attorney General considered the licensee's ability to pay. As I already mentioned, there's a 7-month payment plan to pay out the civil penalty. The civil penalty amount was reasonable. If it had gone to hearing, there could have been a much higher civil penalty in the amount of about $80,000. Respondent has also provided a plan of correction, which is detailed in paragraph 19 of the settlement agreement, and the CCB staff approved that plan of correction. Plan of correction includes the following. As mentioned before, respondent replaced the inventory manager. Respondent obtained a City of Las Vegas business license and did discontinue deliveries to the City of Las Vegas until it received that business license. The respondent installed and replaced security cameras and ensured its security cameras had proper and unobstructed coverage. Respondent implemented a security malfunction log to ensure malfunctions are timely reported to the CCB. Respondent now ensures that all clone batches are logged and documented with verification first, followed by recording and metric. Respondent has updated its harvest logs to include the final yield rate of processed usable cannabis. Respondent's destruction and waste logs were updated to show confirmation that cannabis waste is recorded as usable before physical disposal occurs. Respondent now ensures that destruction logs and waste logs are recorded in metric correctly and with no variance, and with dual verification for employees. Respondent now requires visitors to enter all required information into visitor logs, which they are now checked and confirmed by the employee hosting each visitor. And respondent submitted the required agent card application for the owner who did not possess an agent card. Based on all of that, the Attorney General recommends and requests the CCB approve the settlement. I'm available for any questions on this, as is counsel for respondent, which I believe today is Jared Jennings.
Thank you. Thank you and welcome.
Thank you, board. I'm Jared Jennings. I represent 1212. Chris covered it perfectly. We'd like to thank Chris and his staff for all the help they gave us in resolving this matter, helping us conform and be in compliance is of the utmost importance. And we feel very comfortable and confident that we can absolutely do that going forward. My client agrees with the terms of the settlement agreement, and we ask the board to approve it. My client is present. If the board does have any questions they would like to ask.
Thank you. Do we have any questions from the board?
Douglas, for the record, the only concern I have is making sure, and it was reflected in the record, that a good record is made as of the transaction. We have suffered, the board and CCB, in terms of violations and settlements. For some reason, the paper only picks up the minor minutia. We do appreciate the work that was put in by the licensee to correct those violations. I don't mitigate that, but unfortunately, we're into a PR game. And so we're accused of fining people for not having hot water or washing hands or things like that. And the violations and settlements are usually a little more serious. And for whatever reason, the press picks up what they pick up. So it needs to be accurately reflected what actually happened, and that the licensee has made efforts to correct those things. And that's why it's being settled and we go forward. So that's just my only concern. I support the settlement agreement, but just make that notation for the record.
Thank you. And I appreciate, I know that a lot of work has gone into this from both parties. And so I appreciate everybody's time and effort, and hopefully we've got, good a good paper to work with so that we can move forward. The last thing we want to see is a business fail, as we say that over and over again. So we want to make sure that we set you up for success, and that's our main goal. We want to keep people employed. We want to keep businesses healthy and prospering, and overall our state prospers. So thank you very much for your work on this. And do we have any other comments from the board members? Okay, with that, we'll just bring it back to the board, and we'll act on this item. Is there a motion for approval of the proposed settlement agreement?
Member Mazarano motions to approve the proposed settlement agreement to resolve disciplinary action.
And this is with regard to Cannabis Compliance Board versus 1212 LLC. We have a first, is there a second?
Member Douglas, for the record, I'll second it.
Okay, any discussion on the motion? No discussion. With that, all those in favor say aye. Aye. Any opposed? Was that an aye? Member Durrett?
Yeah.
Thank you. Okay. All right. The ayes have it. Motion passes. Thank you very much. Okay, now we go on to our transfers, our request for transfers of interest. We have 3 items under this agenda item, starting with Redwood Warehouse LLC for possible action. Do we have anyone on behalf of Redwood Warehouse LLC?
Maybe I shouldn't have sat in the back.
Gonna make you walk all that way every time.
Get your steps in today.
Yes.
Chair, do you want me to read the item?
Yes, please. Thank you.
Chair Guzman, Freilich, Vice Chair Durrett, Justice Douglas, and Dr. Mazarano. For the record, I'm David Staley, Division Chief of Investigations for the CCB. I'm here to present agenda item number 5, which consists of 3 transfer of interest or TOI applications. Item A is a TOI application by Redwood Warehouse LLC, TOI number 240001, was filed requesting approval for the transfer of half of one member's ownership to their ex-spouse pursuant to their stipulated decree of divorce. Pursuant to their divorce decree, Leon Taheri Kermani will transfer 10% of his current 20% ownership in Redwood to his ex-wife, April Clyde. Redwood Warehouse has also requested a waiver of NCCR 5.110 pursuant to 5.112 for transfers of interest of less than 5%. Staff suggests that if approved, the board limit Redwood Warehouse's 5.112 waiver to expire on its next TOI agenda date. No areas of concern were developed during this investigation. I am available for any questions, and my understanding that Amanda Connor is available to address any questions you may have as well. With that, Chair Guzman Freilich, I will turn this item back to you.
Thank you, Mr. Staley. Ms. Connor, what do we have going on here? Just a spouse taking over half of another member's share?
Yes. Good morning, Chairwoman Amanda Connor with the law firm of Connor & Connor on behalf of the company Redwood Warehouse. This was as Mr. Staley indicated, one member's interest pursuant to a divorce decree and subsequent settlements. He's giving up half of his interest to his ex-spouse. And so it's a total of 10% of interest transferring to Miss Clyde.
Thank you. Are there any questions from the board? Seems like a pretty straightforward transaction, transfer of interest. Any concerns or questions or thoughts from board members? Any additional comments, Ms. Connor?
None at this time.
And with that, I'm prepared to take a motion.
Member Douglas, for the record, move for approval of the TOI, in this case as the 240001 for transfer of interest and that we would waive NCCR 5.110 pursuant to NCCR 5.112 until the next time this matter appears.
Have a first, is there a second?
Member Mazarano seconds that.
Thank you. Any discussion on the motion? All those in favor say aye. Aye.
Aye.
Any opposed? Motion carries.
Thank
Okay,
you.
thank you so much.
Yeah, and thank you to Mr. Staley's staff. This was a great process to go through.
Nice to hear that. Thank you very much for your comments. We appreciate that. Okay, next we are going into item B under this agenda item, and this is Vices One LLC.
Chair Guzman, Freilich, members of the board, David Staley for the record. Item B is a TOI withdrawal application by Vices One LLC. TOI number 2300001 was filed requesting approval for Vices One to sell its cultivation licenses to Green Buds LLC. During its January 2023 board meeting, the board approved the relationship between Vices and Green Buds related to an MSA, but Green Buds has been unable to meet the payment requirements to purchase Vices One's licenses. As a result, on January 29th, 2024, Vices terminated the purchase agreement and the MSA. Vices has requested to withdraw TOI number 2300001 and advised the CCB that the relationship pursuant to the MSA should be considered terminated. No areas of concern were developed during this investigation. I am available for any questions, and my understanding is that Barbara and Clayton Hurst and Delbert Cannon are available to address any questions you may have as well. With that, Chair Guzman Freilich, I'll turn this item back to you.
Thank you very much, Mr. Staley. I see that we have Kelly Hurst on Zoom. This would be the time then for any presentations. Do you have an affirmative presentation? Hi, come on. Good morning.
I'm Delbert Cannon
Okay,
for Green Buds.
great. Okay, so we've got two presenters, and who wants to go first? Go ahead. Do you want to go ahead? Do you have a presentation of any sort? Or?
No. We agreed to cancel the TOI, so it's no problem.
Okay,
Thank you.
thank you very much.
You're welcome. That's it.
Well, we might have some questions. It's hang tight.
Yeah.
Okay. Go ahead, Mr. Hurst.
Yeah, it's a mutually agreed cancellation, so I don't have any further to add.
Okay, any questions or comments from the board? With that, I'll take a motion.
Member Douglas, for the record, the board accept the withdrawal of this item for a TOI.
We've got a motion. Is there a second?
Member Mazarano seconds that.
Any discussion on the motion? All those in favor say aye. Aye. Any opposed? I know we have a little bit of a backlog, so Ms. Durrett, that's an aye. Okay.
Yeah, sorry.
Thank you. Motion carries, and thank you for being here.
You're
Thank
welcome.
you.
Thank you very much. Thank you. Okay. Okay, we'll go on to our last transfer of interest item, and this is High Sierra Holistics LLC and Nevada Organic Remedies LLC. Mr. Staley.
Chair Guzman Freilich, members of the board, for the record, I'm David Staley. Item C is a TOI application by High Sierra Holistics LLC. TOI number 2400007 was filed requesting approval for High Sierra to purchase a Reno dispensary license from Nevada Organic Remedies LLC and its parent company, The Source Holding LLC. This TOI was expedited because The Source is in the middle of a receivership. High Sierra has also requested a waiver of NCCR 5.110 pursuant to 5.112 for transfers of less than 5%. Staff suggests that if approved, the board limit High Sierra's 5.112 waiver to expire on its next TOI agenda date. No areas of concern were developed during this investigation. I am available for any questions, and my understanding is that Jacques Santucci and Russell Ernst are available to address any questions you may have as well. With that, Chair Guzman-Freilich, I'll turn this item back to you.
Great, thank you very much. Good morning again. Do we have affirmative presentations? Or just here for questions?
Good morning, Amanda Connor, law firm of Connor and Connor. On behalf of Nevada County Remedies, with me is the receiver, Jacques Santucci. We can answer any questions you may have about the receivership. I believe there are also people on behalf of High Sierra up north.
Okay, thank you very much. Good morning up north. Do you have any comments or?
No, there's
any
no
affirmative-
comment. I'm sorry for the delay. My apologies. No, there's no affirmative presentation. This is Jim Pusey on behalf of High Sierra Holistics, and I have Russell Ernst here with me, and we are more than willing to answer any questions that the board may have. And thank you, Chairwoman Freilich and the members of the board for hearing this matter.
Great, well, I appreciate that. Thank you very much. And for your client, does he still have his karate school?
No, I sold those a long time ago.
Okay, I have always liked karate. I always imagined in my dreams that I, would have a black belt, but I know it's a lot of work. I'm too old to try to go back and get my black belt now. Thank you for being with us. Any additional comments? Any questions from the board with regard to the receivership? Or with regard to any items with regard to this item and the transfer? Okay, doesn't sound like it. Any additional comments from the parties?
No, we just thank Mr. Staley and his staff. As he mentioned, this was done on an expedited basis due to the receivership, and we appreciate all their hard work on this to bring this item to you guys.
Thank you.
I just want to add thank you also to your team for helping us through the receivership and what's coming up.
And it's always nice to hear when things work out, especially with regard to when there's a receiver involved. So this is a good outcome. So thank you all. Any additional comments from the board? Okay, I'll take a motion.
Douglas, for the record, I share the chair's comments, thanking the receiver for the work they've done and getting this matter resolved, and wishing High Sierra the best going forward. The motion would be for approval of the TOI in this particular matter as to 24-00007, 100% transfer of an adult use dispensary, RD 219, from Nevada Organic to High Sierra, with the waiver of NCCR 110 pursuant to NCCR 5.112 until the next time this matter appears before us.
Thank you. Okay, we have a first. Is there a second?
Member Mazzarano, second.
Thank you very much. All those in favor, or actually any comments on the motion?
Chairwoman.
Yes.
Sorry to interrupt. Mr. Santucci reminded me, there is a process of going to the city of Reno as well to receive approval. So in the interim, the receiver will still be over, and we'd ask the point of contact and that process not be completed until all approvals from city of Reno and the court are obtained.
Okay, and I'm sure that staff will communicate that with you.
Yeah, because the receiver technically, until he's relieved, is still a party.
Correct.
And the receiver could apply to be removed once that's happened. And, technically that could be done without an order under the new regulations, as long as the chair approved that, or you'd come back here for a vote to get him formally removed from the licenses.
Then I guess, Chair, I would amend the motion to add that it's approved and would not take effect until the receiver is relieved.
Thank you.
Okay. And we're going to ask for your approval of his amendment of,
Member Mazarano approves. Honorable Judge. His amendment to this motion.
Just to clarify the record, I'm sorry to interrupt, but he will remain receiver on some of the other source licenses. So these are only for, he would only be removed off these particular licenses, and he's still on the others.
correct, this item. Okay,
Thank you for the clarification.
Does that work?
all right, so,
Good. We're here.
good. Thank you. I'm glad. It takes a village to make items go through. Okay, so we have an amended motion on the table with regard to the approval of this transfer. And we will jump through all the hurdles that need to be gone through to make this happen. So with that, is there any discussion on the amended motion? Hearing none, all those in favor say aye.
Aye.
Aye. Aye. Any opposed? Great, motion carries. Thank you. All right, thank you.
Thank you very much.
I want to, thank you. Okay, I'm going to go ahead and make a change in the agenda that I didn't do at the beginning, but item 8 on our agenda is 2 petitions filed pursuant to Senate Bill 277. We're going to move that to the very end past our regulations. So with that change, then we'll move forward to item 7. All right, item 6. So item 6 is a consideration of license agreements, starting with item A. This is the Fortress Equities ORCL LLC and SoHi Holdings LLC. This is for a management services agreement. We have the parties here. Welcome. Thank
Sure.
you.
Good morning, Sean
Yes.
Freilich,
Staley.
members of the board. For the record, I'm David Staley. I'm here to present agenda item number 6, which consists of 6 management services, production, and lease agreements. Item A is a management services agreement between Fortress ORCL LLC and SoHi Holdings LLC. While Fortress is currently operating its cultivation license in Pahrump, Nevada, this MSA provides for SoHi to invest significant sums of money to completely update the facility and manage operations going forward. The MSA provides for SoHi to retain 75% of gross profit and Fortress to retain the remaining 25%. A potential TOI between the parties has been discussed, but would likely not be pursued until the renovated facilities are completely operational. CCB staff have reviewed the agreement and found the relationship between the parties appropriate. I am available for any questions. My understanding is that Jared Kahn, John Gorst, Dean Halali, and Kang Yang are present to address any questions you may have as well. With that, Chair Guzman-Freilich, I'll turn this item back to you.
Thank you very much. If you could state for the record your name and any affirmative presentations that you might have.
Good morning, Dean Jalili with Fortress Equities ORCL.
Okay.
Good morning, Jared Kahn, attorney representing SoHi Holdings LLC. And as Mr. Staley said, Kang Yang and John Forrest are here.
Okay. Tell us what's happening here.
Thank you. Thank you, Chair and members of the board. Essentially, it's pretty simple. My client is coming in. They're going to, as Mr. Staley indicated, invest a significant amount of capital into improving the facility and get it operational to maximize the potential from that facility. Mr. Yang has quite extensive experience. He's currently licensed operating about a 370,000 square foot facility in Salinas, California. And Mr. Gorst, who is going to be oversight of compliance, has 12 years in the industry and was an actual former licensee here in Nevada. And now he's coming back to Nevada for this purpose to be kind of the audit oversight for the facility. Essentially, we've been working with Fortress in a very amicable manner. And if this does turn into a TOI, we'll present that at that time.
Okay, great. Any questions from the board members?
I don't have a question. Member Douglas, for the record, I don't have a question, just a comment. I appreciate the presentation. Very quickly, you answered my questions. because I made a note as to who is the party. We have one person always because they're getting a card, so we know who they are, the background. The other parties in the organization, as a board member, we don't know. I was talking to our staff and they said, well, we looked and everything was fine. I said, you need to give us a kind of a heads up because we're charged with making sure you're not a full licensee, but when you're taking that much money, hopefully in profit, out and paying our licensee little, in general, the aspect is we don't want people who are actually running the business, controlling the business, but aren't licensed here. So that's the only concern. You answered that straight up, so I'm very appreciative. And I'm ready for myself to say it's fine, it works. I mean, the parties decided the money's work. That's not my concern.
Board members, any additional questions or concerns on this item? Nope. Okay. It always makes me happy to see the synergy, or well, all that when there's no comments, but also to see the synergy within companies to make something work in this state. So I appreciate your efforts. And with that, any additional comments that you might have or concerns or
This time, thank you.
questions?
The only thing we'd like to thank Mr. Staley and his staff and the rest of the members of the team for processing this.
Great. I'm glad it's all working. Thank you. Okay, with that, then prepared for a motion. Is there a motion on this item for approval of this management services agreement?
Item, Douglas, for the record, items 6A Fortress Equities, ORCL LLC, RC 011, and So High Holding. I'd move for acceptance of the management service agreement.
Is there a second?
Member Mazarano seconds that motion.
Okay, we have a first and a second. Any discussion on the motion? No discussion. All those in favor say aye.
Aye.
Aye. None opposed. Motion carries. Thank you very much and good luck.
Thank you.
All right, take care. Okay, now we go on to item B, which is Greenmart of Nevada, NLV LLC, and AP Management LLC for a management agreement approval. Mr. Staley.
Chair Guzman-Freilich, members of the board. I'm David Staley for the record. Item B is a management services contract between Greenmart of Nevada NLV LLC, a subsidiary of Ianthus Capital Holdings, and AP Management LLC. The MSA provides for AP to provide management direction to Greenmart's existing cultivation and production operations and provide assistance for Greenmart for final approval of its conditional dispensary licenses. Any profit will go to AP Management after all Greenmart expenses are paid. This MSA has been entered into in preparation for the acquisition of Greenmart from Ianthus by AP Management. The TOI was filed with CCB staff on April 5th, 2024, but has not yet been assigned to an agent. CCB staff has reviewed the agreement and found the relationship between the parties appropriate. I'm available for any questions, and my understanding is that Maggie McClutchy, Jared Kahn, Richard Proud, and Arash Yazdapana are present today to address any questions you may have as well. With that, Chair Guzman-Freilich, I'll turn this side back to you.
Thank you. Ms. McClutchy.
Good morning. I'm here on behalf of Greenmart of Nevada, NLV LLC, and its parent company, Ianthus Capital Holdings. Actually, on behalf of Ianthus and Greenmart, we have Mr. Justin Vu, who is the Chief Financial Officer, Interim Chief Financial Officer. We also have on Zoom Aaron McCarthy, who's the Vice President and Associate Counsel for Ianthus. As Mr. Staley mentioned, this is a management agreement that's being entered while a TOI is pending between the parties.
Thank you.
Good morning,
Good
Chair
morning.
Freilich, members of the board. Again, my name is Jared Kahn. In this transaction, I represent AP Management LLC, which is essentially an affiliate entity of 3AP Inc., which does business as Nature's Chemistry here, an existing licensee in the state of Nevada with a stellar track record and a stellar reputation in this industry. As part of this transaction, as was presented, this is an MSA pending a TOI that the AP Management and their affiliated entity are going to be purchasing all of the Nevada licenses from Green-Mart of Nevada LLC. And with that, happy to take any questions.
Okay, thank you. And thank you for being with us on Zoom. Do you have any presentations or any comments? I know you have able counsel here, so we appreciate that.
They're available if there are any further questions, but we don't have a further detailed presentation.
Okay.
Except that I did want to thank Mr. Staley, Rachel Branner, and Monique Patton, who worked on this, the staff that worked on this, this management agreement.
Thank you. Appreciate your comments. Okay, with that, I'll bring it back to the board for any, well, actually, any questions from the board members with regard to this transaction.
Douglas, for the record, this one is a little easier because we have a TOI and it gives us more information. The only question I have, what's your hope for closing date on the asset purchase? Any rough timeline?
Maggie McCletchie, for the record, my hope is that as soon as possible. I think the TOI, I think as Mr. Staley mentioned, has not yet been assigned, but the hope, this is an interim agreement, that it is not the end goal. The end goal is to get the purchase agreement approved as soon as possible.
Looking at it and saying your management service won't take effect until this happens and so on. So going through, that's why I was asking what the hope for date. So, but anyway, but other than that, it's like you're in order. I don't have a problem with this.
Yeah, Your Honor, I think it's just dependent on getting the TOI processed, and then I think the closing is set for one day after TOI approval.
Great. Okay. Any additional comments or any questions from the board members? Okay, with that, I'm prepared to take a motion.
Okay, Member Mazzarano makes a motion for Green-Mart of Nevada, NLV LLC, RC 037, RP 018, RD 504, RD 507, RD 511, and AP Management LLC. Motion to approve that management agreement.
Second.
Douglas, for the record, I will gladly support the motion made by my colleague.
Perfect. Thank you. Thank you both. With that, we have a second. Any discussion on the motion? Hearing none, all those in favor say aye. Aye. Any opposed? Motion carries. Thank you very much and good luck.
Thank you very much.
Seeing that transfer.
We do too.
Okay, going on to item C. This is Silver State Wellness LLC and Brand House NV LLC. Mr. Staley.
Chair Guzman-Freilich, members of the board. For the record, I'm David Staley for the CCB. Item C is an MSA between Silver State Wellness LLC and Brand House Nevada LLC. Silver State holds production and distribution licenses in Las Vegas, Nevada, and the MSA provides for Brand House to manage the day-to-day services of those licenses for no compensation. A TOI is expected to be filed in the future for Brand House to purchase Silver State's licenses pursuant to a February 1st, 2024 asset purchase agreement. CCB staff have reviewed the MSA and found the relationship between the parties appropriate. I am available for any questions, and my understanding is that Michael Hayford and Scott Knudsen are present today to address any questions you may have as well. With that, Chair Guzman-Freilich, I will turn this back to you.
Thank you, Mr. Staley. Good morning.
Good morning.
Presentations.
No presentation. Michael Hayford representing Silver State Wellness.
Scott Knudsen representing Brand House.
Okay.
Yeah, I don't have a formal presentation, but happy to take any questions about my history and background.
Perfect. Okay. Any questions from the board members?
Member Durrett, for the record, I was just wondering about the general status of Silver State. That's Las Vegas Relief, right? So what's happening there? Because I've just, I've heard some ups and downs, and it was one of the original founding companies back in the medical days. I know one of the owners was, I'm not sure if he still is, Ed Bernstein, who's somebody really involved in a lot of philanthropic efforts, which we like to recognize here at the CCB. So I'm just wondering, what's the overall picture right now?
Well, the overall picture is we're in the process of selling all of our licenses. In this particular instance, we did submit a TOI just last Friday for this matter. Last week, we entered into an agreement to sell Las Vegas for Unifer dispensary. We have submitted an MSA on that 10 days ago. We expect to submit a TOI on that in the next probably 10 days. Then we have a third transaction that will follow regarding our cultivation.
How did the alcohol beverage go? Because you guys put a lot of investment into that and it was really exciting. And I think these intoxicating hemp beverages are, kind of sweeping in some states. So I would hope that yours became as wildly successful as planned. How did that pan out?
It actually went really well up until kind of COVID caught up. We spun the brand off Cannabis. It did so well in cannabis. We decided to introduce it. The brand was Two Roots Brewing Company. It was the world's first non-alcoholic cannabis infused craft beer. We introduced it in Las Vegas in 2018. We actually had the governor. I think Sisolak was not quite governor yet when he was for the grand release of that product. It did very well in Nevada. We then introduced it to California. We ran into some challenges with distribution processes in that state, which kind of, those headwinds had us say, well, why don't we look at the traditional markets, because the basis for that product development was looking at the global growth of non-alcoholic beer worldwide. We introduced it to California's retail distribution as a non-cannabis product, and it performed exceptionally well across about 300 stores, second only to Heineken 0.0. We then introduced it to the world's largest beer competition in Colorado. And 3 years in a row, we won medals, gold, silver, bronze each year. And then by the end of 2023, we were in 26 states, 8 countries, and we signed a transaction with Molson Coors to supply the same product to them in Canada to be within their cannabis beer offering there. So that product did very well for a while.
That's
okay.
Really
Really,
good one.
oh, could I ask one more question?
Oh, absolutely.
It's great. Somebody does that.
Actually, two. One, well, is that being sold along with all the other licenses? And two, what are you going to do after this? Because this has been what you've been doing for 10 years, right?
Yeah, no, I appreciate that you remember that where we came from. We were on the dispensary side, we were the first to open in the city of Las Vegas in 2015. We were the third to open in the state at the time. We opened our manufacturing facility, our production in 2016, and then in 2020, we opened our cultivation. In 2021, we spun off the beer division because of there's tension between our cannabis roots and alcohol distribution, which is where the product need to get distributed. So we spun that off in 2021, gave it its own organization, its own leadership, and let it run. And today, all of our founders are, they're all professionals. They had full-time jobs, and we're all going our own way and starting new things for some of us.
Thanks. I'll save the rest of the questions for when the transfers actually come on at the agenda. Thanks.
Not a problem. Thank you for remembering all those points.
Wow. Yeah. Remember, Durrett knows all. Okay. All right then. With that, we have a motion.
Just for the record, I move for the acceptance of the management service agreement. And just an odd comment going through this, is like I had to look at it twice, because first time I've seen where there's no money changing hands, so to speak, for the management service, but it goes along with the underlying acquisition and movement of overseeing the business to get it going the right direction. So with that comment, my motion is for approval.
We have a first, a second.
Member Mazzarano seconds that motion.
Thank you. Any discussion on the motion? None. All those in favor say aye.
Aye.
Aye. Any opposed? Motion carries. Thank you very much. Good luck.
Have a great day.
Thank you, you too. Okay, now we are going on to item D. This is Unifer LLC with regard to an incomplete management service agreement. Mr. Staley.
Chair Guzman Freilich, members of the board, for the record, I'm David Staley for the CCB. Item D is an MSA between Unifer LLC and Herba LLC. Unifer holds cultivation and production licenses in Henderson, Nevada, and the MSA provides for Herba to deliver various business and consulting services to Unifer for 10% of Unifer net revenue. Various areas of concern have been developed during this investigation, including the lack of a fully executed agreement between the parties and lack of any response from either Unifer or Herba. As the board is aware, the Investigations Division is tasked with investigating every transfer of interest and management services agreement submitted to the CCB. In addition, some TOIs arise from receiverships, and the division expedites these applications to ensure that the assets under receivership retain as much value as possible for the benefits of the licensee and the cannabis industry as a whole. The division balances the demands of regular applications and expedited applications, and each agent is assigned multiple investigations at once to maintain as orderly a flow of items before the board as possible. In the case of Unifer and Elba, ignoring multiple requests for information and lack of a signed and executed agreement require the agent to make multiple attempts to get the information they need, thus interrupting the flow of all of their investigations and impeding the process of completing investigations where applicants are responsive and interested in moving forward. As a result, staff suggests that the board deem this MSA application incomplete and strike it from staff's workload due to an incomplete agreement and lack of responsiveness. If Unifer and Elba are still interested in pursuing a management services agreement, they will need to submit an executed agreement along with a new request for approval and wait until all of their existing MSAs are assigned before their new application will be assigned. I'm available for any questions, and my understanding is that John Coletta, Simone Steiner, and Dragan Jovanovic were noticed to appear today to address any questions you may have as well. With that, Chair Guzman Freilich, I'll turn this item back to you.
Thank you very much. Hi, welcome.
Good morning, Chairman Freilich. James Call on behalf of Unifer, and we would request a deferral on the basis that we are the licensee. We did not submit this for approval to the board. We are unaware of who did so, and we would certainly like to touch base with the investigator to find out who actually submitted this application. We are under the belief that the management company has failed to meet the conditions precedent to take over the operations of our operations, and so this should not have been submitted. So we only got notice when excuse me, when the notice to appear today came in. That's the first time we learned that this had been submitted, and so we asked it to be taken off calendar until such time as we are ready to submit it. And the alternative, we would request that you deny it without prejudice, and then resubmit at such time as the proposed management company complies with the conditions precedent of the agreement.
Mr. Cole?
Yes.
Okay. And what's your position with Unifer?
I am an attorney. I represent
your counsel.
Howard.
Oh, thank you. Okay.
Chair Guzman Freilich,
Yes.
the staff would be comfortable with the denial without prejudice.
Okay. All right. So I just want to make sure I understand though. So Unifer did not submit this. It was the management company that submitted.
We believe
this?
that's what happened, but definitely Unifer did not submit this. We don't think it's ready for submission because, again, as I said, the management company has not complied with the conditions precedent of the agreement.
And has Unifer, that you know of, have they received any information from our staff? Any phone calls or letters or?
I don't know, honestly.
Okay, so your client didn't tell you whether or not we've been trying to get a hold of them?
Did not.
Mr. Staley, didn't we try to reach out, staff tried to reach out to Unifer? specifically,
I
or?
believe we did. There are some new lawsuits in Florida that we were trying to get information on. The report indicates that the agent was unable to make inquiries into this matter because the POC for Unifer didn't respond.
Okay. If you could just remind your client that if our staff calls, because they have such a huge workload, as everybody does, but every attempt to try to get an answer, it's just more time that is taken instead of them focusing on other items. So, yes, if you could just let your client know, if we call, they need to call us back or write us back or do something so that we're not constantly trying to chase them. But with that, yes, I have no issue with just, denying it without prejudice. Judge, this is right up your alley. What do you recommend?
No, I was just rubbing my head because I was thinking about something that's been in the news recently, and that was the Elvis Presley estate. And a group who was trying to say they owned it and going to court to sell it. And they had no interest in it whatsoever. I would ask that our staff at least get back to us about the ability of someone who's purporting to go in to run something, submitting something to us and not the licensee themselves. At least what happened on this one, so it doesn't happen again. I don't have any problem with withdrawal with prejudice, or just outright denial without prejudice.
Okay. So legal question, ramifications, either one of you, the ramifications of the dismissal versus the denial without prejudice.
Well, if it was an application to approve a management service agreement, I think you could certainly deny it without prejudice to bring it back again.
Mm-hmm.
Because Mr. Saley said it probably go down to the bottom of the list at that point, but
And it's
it is
without
what it is.
prejudice, so
It's without prejudice.
Okay.
That's my thought.
Thank you. With that, any comments or concerns or questions from board members? We have a motion?
Just for the record, motion for denial without prejudice.
We have a motion. Is there a second?
Member Mazzarano seconds that motion to deny without prejudice this complete management service agreement.
Thank you. We have a first and a second. Is there any discussion on the motion? Hearing none. All those in favor say aye. Aye.
Aye.
Any opposed? Motion carries. Okay, thank you very much.
Thank you.
Okay, moving right along to item E, which is Greenscape Productions and Optimum Extracts LLC. This is for a production and packaging agreement.
Chair Guzman-Freilich, members of the board, for the record, I'm David Staley with the CCB. Item E is a production and packaging agreement between Greenscape Production LLC and Optimum Extracts LLC. Greenscape holds production and distribution licenses in North Las Vegas, Nevada, and the MSA provides for Greenscape to manufacture and sell Optimum branded product using Optimum intellectual property and packaging materials for 15% of gross revenue from the sale of Optimum branded products. CCB staff have reviewed the production and packaging agreement and found the relationship between the parties appropriate. I am available for any questions, and my understanding is that Wee Chen and John Welliver are present today to address any questions you may have as well. With that, Chair Guzman-Freilich, I'll turn this item back to you.
Thank you, and welcome, gentlemen. If you can state your names for the record when you speak for our court reporter.
My name is Wei Chair. I'm owner of this Greenscape Production.
Okay, welcome.
John Welliver, the owner of Optimum Extracts.
Okay, thank you. Do you have any presentations, affirmative presentations, or just available for questions?
Just available for any questions.
Okay, any questions from the board?
I have a couple questions. Member Durrett, for the record. I guess first question for staff is, well, we discussed this and I just wanted to confirm, we typically don't have white labeling agreements on the agenda. we've had discussions a couple times about whether we would, and the resolution was that we'll hold off unless or until the board has a discussion about whether we want them on the agenda in general. So this one is on the agenda because they affirmatively asked for it, right? To be
Yes,
on-
Member Durrett. David Staley for the record. That's correct.
So, for the representatives of the entities, I'm curious why you requested approval for this. Is it just because you thought it was required, or you just thought it would be better to get approval and not have issues down the road, something like that? Because you weren't required to ask for approval for this.
We request approval, right? I think we can approve, right? I think is
That's why you're here.
okay.
So
So what's the question? I'm sorry.
what made you come here and ask for approval?
Oh, I thought I just received a letter. That's why I'm coming here.
Okay.
The name here is a request coming here to attend this the meeting.
Okay.
Well, I guess you're talking about the notice of appearance, but you submitted an application asking for it. You're not in trouble. I'm just curious. I just want to know how all these work.
Because all submitted on my compliance all this.
No, when you asked us to approve this, when you didn't necessarily need to. I'm just wondering if you thought you needed to, or you just thought it was better to check in with the regulators at the outset of this relationship and you just felt more comfortable doing that.
Yeah, I thought I wanted to come and check it, but.
Okay.
She said you required to get approval for them. You could have approved it, but yeah, maybe it was just a misunderstanding.
Yeah, so maybe I think it is.
Well, better safe than sorry, right?
Exactly. That's why if I don't come,
So,
this.
It's good to be proactive.
So I'm here, so Lisa, I know, I heard this.
Yeah.
Okay.
Well, you weren't required to, but now you know you'll definitely have an answer, so there won't be any issues down the road. Okay, thank you.
Thank you.
Any additional questions from the board? No? Any additional comments from you before we bring it back from motion? Okay, well, I appreciate you being conscientious and coming to us. Like I said, it's better to be proactive, and if we do make it necessary, you're already there. You're the first one, right?
Yeah.
Yeah. Okay, so with that, any additional comments or questions or concerns from the board? I'll take a motion.
Member Mazzarano motions to approve Greenscape Productions LLC C136P080 and Optimum Extracts LLC for a production and packaging agreement.
Second the motion for approval.
Okay, we have a first and a second. Any discussion on the motion? Hearing none, all those in favor say aye.
Aye.
Okay, motion carries. Thank you very much and good luck for you. Okay, thank you. Item F on the agenda is Commerce Park Medical.
Sure, we pulled that.
Oh, that's, okay,
Yeah.
that one's pulled. Oh, that was the Alpine. Okay, the lease. So no item F that has been withdrawn or pulled. And so then next we have, does anybody need a break? Okay, we'll move on to item 7, which is the consideration of an order to show cause. Mr. Rath, will you be presenting on this?
Chair, I have a.
Oh, you have, okay, thank you. Mr.
And then
Bailey.
Chris and I will be available for any additional
Questions? Okay.
Chair Guzman, Freilich, members of the board, for the record, I'm David Staley with the CCB. I'm here to present agenda item number 7, which consists of one order to show cause. Item A is an order to show cause why the board should not deny a TOI application for Strive Wellness of Nevada. On July 25th, 2023, the board approved a stipulated settlement agreement which required 2 of the 3 owners of Strive, Lawrence Lemons and Donald Burton, to submit a TOI and sell their ownership interests within 6 months. On January 17th, 2024, Lemons submitted a TOI application 24001 requesting approval to sell Strive's non-operational cultivation and production licenses to Item 9 Labs Corp. However, TOI number 24001 was incomplete as filed because it did not include required signatures from Burton and Sarah Gullickson, two of the three Strive owners. Board agent made multiple requests to Strive to have Burton and Gullickson sign the TOI application, but the requests have been ignored, as well as requests for additional information to continue the TOI investigation. Additionally, item 9 has claimed in its public filings to own Strive's cannabis licenses since February 18th of 2020. The purchase of Strive's licenses by item 9 has not been approved by the Nevada Department of Court Taxation nor by the CCB. Item 9 is currently in receivership and has announced plans to sell the Strive licenses in its public filings. Additional information has not been reviewed due to an incomplete TOI application and refusal to provide additional information as requested by the owners of Strive Wellness. Much like the Unifer MSA discussed earlier, lack of responsiveness from Strive in relation to its TOI application interrupts the flow of all investigations and impedes the process of completing investigations where applicants are responsive and interested in moving forward. In addition, it appears that Lemon and Burton have failed to comply with the July 25th, 2023 stipulated settlement agreement, which required them to submit a TOI to the board within 181 days, as the TOI submitted within that time was not complete. In addition, since the order to show cause, counsel for a third party, East Betty, Nevada, contacted the CCB and claimed that East Betty had obtained the right to purchase Strive from item 9 via a settlement agreement in item 9's receivership action. That attorney may be present here today to explain this matter further. As a result, the board has several options after hearing from all interested parties. The board may deny this incomplete transfer of interest application due to lack of cooperation from the applicant and apparent unapproved TOI, and may direct the executive director to transmit details of the suspected violation of the July 25th, 2023 stipulated settlement agreement to the Attorney General's office for review. Number 2, if requested, the board may grant additional time for submittal of a proper and complete TOI, which may involve a direct TOI from Strive to East Betty or a TOI from Strive to item 9 and then East Betty. Number 3, if a proper TOI is submitted, the board may still consider referral for disciplinary action, which may be considered at the time of the proper TOI. I am available for any questions, and my understanding is that Larry Lemons, Donald Burton, and Sarah Gullickson were noticed to appear today to address any questions you may have as well. Jean Connell, counsel for item 9's receiver, has requested to appear as well. With that, Chair Guzman-Freilich, I'll turn this item back to you.
Thank you very much. Who do we have other than Ms. Connell for presentations or for questions? If you could come up to the front, please.
Chair, can I make a disclosure on this?
Yes, please.
Everyone's probably sick of this disclosure by now because I've made it multiple times, but I'm going to abstain on this matter. I was retained years ago to provide expert witness services to a law firm that represented parties that were opposing this current licensee, the owners of this license. So I don't think that it would impair my judgment, but I'm going to abstain in abundance of caution.
Sarah, that's appropriate. Okay.
Chair Guzman-Freilich, barring an appearance here, I will note that Larry Lemons, Donald Burton, and Sarah Gullickson were all appropriately noticed outside of in accordance with public meeting requirements.
And I'm mainly concerned with Mr. Lemon and Mr. Burton. Are they not here today? Out in the audience, do we have Mr. Lemon or Mr. Burton here present? It doesn't look like it.
Madam Douglas, for the record, Madam Chair, do we have the receiver present today or their attorney so we can at least hear from them as to what's going on in this matter? And
hello, this is Mr. Lemons. I am here.
Oh, Mr. Lemons is on the phone. Okay.
Chair or Member Douglas, for the record, the receiver was over the Harvest Foundation. So
that's
it's not a receiver over Strive, not a cannabis receiver over Strive.
Thank you for that clarification. that's something we don't need here.
Okay, so it
And
looks
then-
like, yes,
Sorry, Sarah Gullickson is here too. I keep hearing that I'm not here, but I'm here via Zoom because I submitted a request to be a part of the meeting via Zoom. So I'm here for any questions, comments, or concerns.
okay, and Ms. Gullickson, who do you represent?
She's one of the
I'm
owners
on
of
the
Strive.
Strive. Yeah, I'm one of the owners of Strive. Yep, thank you so much.
Thank you so much. Okay, so no, so that we do have Mr. Lemons on the phone. We've got Ms. Gonell and Ms. Gullickson. Anybody else with regard to this item? Any other parties that are here for any questioning or comments? Okay.
Chair Guzman-Fralick, I'd like the record to note that despite an appropriate notice that it appears that Donald Burton is not in attendance and has not appeared as required.
Okay. I have a quick question for staff before I ask Mr. Lemons some questions, but on that stipulated agreement, wherein Mr. Lemons and Mr. Burton were to sell their interest in Strive within 181 days, has that 881 days lapsed? Date?
It has.
It was 180 days to submit a TOI.
Oh, 100, okay.
Not to complete a sale, but to submit a TOI.
That has not occurred?
It has not. Mr. Lemons supplied a TOI with his signature on it, but Mr. Burton has not participated in this process.
And we didn't have Ms. Gullickson's signature on it either, so it was only signed by one out of the three owners.
But
One of the three, so only Mr. Lemons had signed it.
and Chair Guzman-Fralick, for the record, David Staley, Ms. Gullickson was not a party to the settlement agreement. It was only Mr. Lemons and Mr. Burton.
She did execute the settlement agreement to make sure she was aware of what was happening.
Okay.
There was no discipline against Ms. Gullickson.
Thank you for that clarification. Okay, so Mr. Burton is the missing piece here. Okay, thank you very much. And my question then is, Mr. Lemons, are you there still?
Yes, I am. I'm here.
Okay. What's going on as far as you know? What's happening? Have you talked to Mr. Burton? Have you been in communication with our staff?
I have not spoken to Mr. Burton outside of his I did see his response to the email request. I'm not sure if he put in to not appear or not. But no, I've not spoken to Mr. Burton on this. We have been, I'm not 100% sure what is going on. I know that we have a party of interest. This has all become incredibly difficult ever since item 9 was put into receivership themselves in regards to how this is all gone about. We did receive feedback, as you all stated. I just got communication that there's a party of interest that has purchased or absolved item 9's quote unquote right to purchase us and are asking for the ability to be able to do so. And I thought they were going to come and represent themselves. I'm not sure if they are or not here as well, but they did say that they would be willing to work with us on anything that needed to be done in order for us to actually submit the TOI and get this license transferred. I know that it is my desire and our desire to get this taken care of. Yeah, I don't 100% know what is going on in regards to, I just know that it became incredibly difficult getting anything worked through or done with item 9 being in receivership. And that now seems to be, I guess, remedied in a sense of they've relinquished their rights to purchase to one of their debtors or a new company that is purchasing them and their assets. And they are now asking us to move forward in that manner, which I am more than willing to do to get all of this taken care of and out of, my name as requested.
Right. And just to kind of like summarize, this is Sarah Gullickson speaking, one of the owners of Strive Wellness. Apologize obviously for the delay. I know that there were several attempts to potentially, put in a request to remove Larry and Donnie. And I think what the conundrum was, are we transferring the interest to me or are we transferring it to item 9? Then we made the decision that it was to item 9. However, since they were in receivership, it just got brought to our attention, 2 days ago or 3 days ago that we were potentially supposed to transfer it to somebody else. Well, we haven't seen settlement agreements. So I guess if there is a remedy that I'm requesting, and I'm sure Jean wants to chime in as well, which is item 9's counsel, is, we need to be able to look at the settlement agreement and take some time to fully understand if that's where the license is supposed to go, and then obviously ask for your approval. So at this point, it was something that I didn't know that we could have like a 10-day extension or something like that to remedy the situation. I'm sure you guys are very familiar with what happens during receiverships. You don't exactly know who to go to or what's exactly happening. There's a hierarchy of decision making. So I definitely apologize for the delay, and that's no excuse. But at this point, we need to like understand all the legal documents and where this needs to go.
And I guess my concern is that the discussion that we're having here and trying to figure out where all the pieces fit should have taken place maybe before we got to this meeting.
I understand, and I apologize. Absolutely.
So, and maybe is it Gonell or Gonell?
It's Gonell. I can kind of, yeah. So
could you, tell us what's happening and what's happened since today.
So we, as item 9, were unaware of the issues pertaining to Donnie, Mr. Burton, and Mr. Lemons specifically. I do not represent Strive, and so any documentation pertaining to Strive would not be something that would be in our purview. With that being said, we submitted a TOI for purposes of item 9 with the understanding that we did believe that a third party was going to be assigned the interest, and thus withdrawing that TOI potentially and then having that new company come in and submit. So I think right now there's kind of three steps in the process to kind of get things moving, if this is okay. So it sounds like Donnie, Burton, and Mr. Lemons need to be removed from the license right now, and we can submit paperwork to effectuate that within 7 days. And I will assist Strive. Again, I don't represent Strive, but I'm happy to help them get all of that paperwork submitted to remove them from the license. At the same time, I think that it's wise that item 9 go ahead and withdraw the TOI that's pending right now, and we can submit that documentation to withdraw the current TOI to item 9 with the plan that the third party and Attorney Melissa Waite is here, and she can talk about that portion, but essentially resubmit a TOI after the removal of Mr. Lemons and Mr. Burton for Attorney Waite's client to take over the license. So I think that there's really an easy path forward. Item 9 was not aware of the issues pertaining to Mr. Lemons and Mr. Burton because frankly, I don't represent Strive, but I'm happy to assist them to kind of get this cleaned up so the license can move forward with the change of ownership to Attorney Waite's a client.
That sounds like a good plan to me, but I will open this up for the rest of the board members to ask questions. And go ahead and come up. Yes. Thank you.
Melissa Waite with the law firm of Dickinson Wright. I represent Pelora Street LLC, who is the ultimate intended owner of these licenses and also the land on which the building currently sits. So my client will be hopefully acquiring the licenses if we can make some arrangements to work through the transfer process. And then we'll also be acquiring the real estate as well.
Okay, and with that, I'm sure that the board members have questions for everybody.
I get, Member Douglas for the record. We started with the failure of Mr. Burton to come forward. And that's kind of an underlying issue. Is that still necessary based on, I guess, court proceedings, or what's going on, if you know?
So, and I would defer to Mr. Rath, but I believe if we have 2 of the 3 owners sign the TOI, that under the regulation, that meets the requirement. I believe the requirement is to have the one individual that's the point of contact sign, or a majority of the owners, or all officers and directors. I think there's 3 ways to complete TOI. So if we have assistance of these 2 individuals, I think we can, get the TOI executed. We have a settlement agreement that shows, that my client's going to acquire the licenses. And I think administratively, if we can work with staff to structure it to make sure it meets all the boxes and checks all the requirements, I think we can move it forward pretty quickly.
Mr. Rath, you've been put on the spot.
Yeah, I know. According to the regulations, all owners are supposed to sign, or all officers. And I don't know who the officers are at this point. Seems like Ms. Gullickson and Mr. Lemons are ready to sign. I don't know if Mr. Burton's MIA. I mean, I suppose the 2 that can sign and come before the board and say they can't find the 3rd person. My other thought is, I'm not seeing why there couldn't be just a withdrawal of the current TOI, because not everybody signed it, and then a direct TOI between the new party and the 3 owners. And then we'd have to consider the unapproved TOI and all that. And I don't have the documents to give you an opinion on that. But it may be more efficient to do a direct TOI and deny the one that's out there because it's not completely signed. And then whether Mr. Burton can sign or not, whether he's an officer or not, I don't know the answer to those questions. But generally, it's either all the owners sign and the transferee signs, or all the officers sign, the transferee signs, and I don't know who the officers are. That's the best I can tell you at this point.
That helps a great deal. I guess at this point, that's a show cause, whether it makes sense to continue the matter for 30 days for its status, as to, based upon this and kind of ruffling the feathers so that all the parties are now aware that they need to get together to give us a report of what's going on and the proceed and how you wish to proceed with this, to withdraw it, to go forward and answer the questions. You do or don't need Mr. Burton's signature. It would be helpful to get that information, get the ducks in a row. And if it makes more sense to withdraw and come with a new one, so be it. But Mr. Staley, you have any thoughts?
I think procedurally how to go forward is a decision that would need to be made by the board. But Mr. Rath is correct. It sounds or sounds right that all of the components are in place that we could get this through the system and get a complete TOI filed and then move forward with the investigation.
My position for me personally is that this is a show cause for us to do something. And it's kind of sounding, the TOI itself is missing some things of the clarification so the board can make a decision. So if we continue this matter, from my standpoint, for a short period, for the parties to tell us this is what it takes from their standpoint to get it all together, or it is together, so we can go forward. But right now, because of response and parties knowing they needed to talk to each other, we have some things we just don't know.
And I agree with you. I think this order to show cause why we shouldn't deny or do whatever on TOI. I don't feel comfortable acting on this order to show cause without all of the missing pieces and missing information, or with the plan, the best laid plan going forward for this company. So with that, any additional comments from board members or any recommendations or a motion? Additional questions from the parties?
Member Mazzarano would just ask, does anyone know why Mr. Burton is somewhat hostile in being willing to sign something?
I don't have any information.
I can speak to that. So I don't think it's hostile and doesn't want to sign. I think that there were a lot of moving parts in the receivership, and I think in his head, he's already done what he needed to do. I can't speak for him because I'm not him, but just observing emails flying back and forth, I understand it appears as though there's a lot of non-compliance happening. I think there's just a lot of confusion and surprises. And so I think that we're all just trying to like really wrap our head around like what our legal obligation is and how we actually pass this through. And so I don't believe getting him to comply is going to be an issue. But that's just my vantage point to add color.
Yeah, I not to, but I agree with you, Sarah. And to the board, I don't think it's going to be a problem to have him comply. I don't believe he understands 100% what is going on. And again, I'm on those emails as well. I believe that it's a situation where he feels he's already done what was necessary. Yes. And it's in somebody else's hands. And so, and again, I think well, actually, I know he did respond that he wasn't going to be able to make it today, and with paperwork, he just, so again, I think if you all give us time as you all are tossing around, and we put the right things in front of him, I do believe that we will be able to get him to sign and come back with something concrete in the time frame.
For the record, Chair, L. Christopher Rath, my recollection is Mr. Burton did sign the settlement agreement, but he has not signed the transfer. And you don't want to transfer something without an owner's permissions.
Right.
Okay, well, as Mr. Staley mentioned at the top of this item, is that a lot of time and energy and effort from staff has been spent trying to get parties to respond to staff. And so for me, it's not just concerning, but it's frustrating. Mr. Staley and I both come from background in gaming. And if any of you have practiced before, look at Ms. Levinson, yes, she has, right. If any of you have practiced before gaming, we wouldn't be here. Because what we've done, what we've talked about here, I think it's productive, but this should not have happened. If staff reaches out to a licensee or an applicant, you have to call them back. You have to return their calls. Otherwise, we're here and we are wasting so much. This was not a waste of time. I mean, this was productive, but it should have happened on the front end. And maybe perhaps by now we would have been able to act on something. So what I'm saying is that if our staff calls, please return their calls. Please answer the letters so that we wouldn't have to be here trying to resolve it in a public meeting. So I would appreciate going forward if you could just call the people back. I mean, it doesn't take much. Just call them back, write them back, email them back. Yes, I mean, they're just doing their job. They're just doing their job. With that,
understood.
Appreciate it. Thank you. With that, any comments, concerns, any additional questions? And if not, then I'll take a motion for whether we want to table this or send it back to staff.
Douglas, for the record, Madam Chair, do you have any recommendation you'd like to throw out for us to make a motion?
Guzman Freilich, may I make a suggestion, please? David Staley, for the record, I would suggest that if the board agrees that it refer this by item back to staff for appearance on the August agenda due to, because we're already wrapping up the reports for July. So I think if we're able to put it on the August agenda for an appearance back before the board, that'll give our agents adequate time to reach out to the parties and to give you a good update with a good decision moving forward, potentially even a new TOI on record to start working on.
Okay, and with that,
Chair, if I may,
yes.
does that, Chris, does that put us in line with the settlement agreement, or are we out of time if we put it on August?
Well, technically, the settlement agreement required a TOI in January, which was submitted, but it wasn't complete. So if you want to look at it as a continuance of the process, I think you could.
So if we just revert this back to staff with the possibility of it coming back to our, I'm not going to hold that August timeline, but I mean, we'd like to see it sooner rather than later. But that would be my recommendation, is just to refer it back to staff and to come back at a later date. What that looks like, I don't know. So can I make a motion? Okay, I'll make a motion to refer it back to staff for a later date to come back to the board.
Member Mazarano seconds that.
We have a first and second. Any discussion on the motion?
My only comment is that it's nice to have kind of bookmarks so things don't get lost. And having kind of a date to say, refer it back to staff, but we'd like to see it by some date. To get the parties to move, all of them come collectively together, opposed to having them spread out like they are presently.
Would you amend my motion then and add a date?
I would add a date. Based on your motion and staff, I'd like to use a September date. That might give them more than enough time. And if they get it together quicker, then they can work with staff about getting it on for August. But September might be a good date. Just keep track of what's going on.
Okay, I accept your amendment. We have an amended motion to, and
Member Mazarano seconds that with the understanding that the parties involved will be very responsive to our staff when they reach out.
okay, we have a first, a second. Any discussion on the amended motion? Hearing none, all those in favor say aye.
Aye.
Any opposed? Motion carries. Thank you. All right, we look forward to seeing something by September.
Thank you.
Thank you, and thank you for being present. Okay, with that, we are on for, right. Item 9, which is the regulations, consideration of regulations, because we moved item 8 to last. With regard to the regulations, we have had workshops, amendments, more workshops on these, and so we will present them. We will have a discussion and vote on them and move them to legislative commission. With regard to public comment, I just want to, we'll accept public comment on all of these regulations. I know you've had opportunities to make your comments, submit your recommended amendments. And if you have the same comments as somebody else, I would appreciate if you just come up and just say, ditto or same or what have you, if it's the same exact comment, just to kind of speed up the process, because these regulations sometimes tend to take some time. It's my intention to not make any more amendments, but we'll hear your comments for the record, because this record can be, presented elsewhere. But these regulations should go forward as they are to the Legislative Commission, and then the Regulation Commission the Legislative Commission will then have workshops on the regulations as well. So it's not the end of the line. And with that, we'll go ahead and open up the regulation one by one. And Ms. Concrete, oh no, okay, all right. Thank you. Okay, Steve, Mr. Miles, go ahead.
Morning, Chair and board members.
Morning.
For the record, I'm Michael Miles, Deputy Director of the CCB. Chief Cronkite and I will be presenting the changes to the regulations for your approval in order to submit them to the Legislative Commission. I'll be covering regs 1, 4, 5, and 6, and Chief Cronkite will cover the remainder of the regulations. All of these changes have been workshopped appropriately, and many have been workshopped multiple times in order to present these changes to the board today. First off, we have Regulation 1, which just adds some clarifying definitions to the regulations, specifically for diversion, intentionally, knowingly, and unlicensed activity. With that, I'll turn it back to Chair.
Okay. Any public comment with regard to Regulation 1? Again, we'll go on in the south and in the north, and then we'll go online with regard to comments.
Good morning, Amanda Connor with the law firm of Connor & Connor, for the record. This comment is more in general to all of the regulations you guys are considering today. I know, Chairwoman, you briefly mentioned it, but I think it would be helpful to clarify. Implementation of these proposed changes will not take effect until after Legislative Commission votes on those, correct? This is under the new APA, and that will take some time. My understanding is if the board passes these today, the wording and language goes then to LCB for them to format, and then they present it to Legislative Commission. So as far as timing for the industry to be clarified, we don't have an exact date on when these will be in effect and implemented, correct?
Correct.
Less than a day. We're still waiting for all of regulations to be converted to the NAC. So
right. I just wanted to clarify that so people know that those passed today, unlike what used to happen, they're not in effect as of tomorrow.
Yes, thank you for that clarification.
Just for Douglas, for the record, just for additional clarification, aren't we required to have certain things done, i.e. our initial recommendation up to on this one, or?
these are the approval of the changes to submit to the Legislative Commission. So these aren't going to be put into to be the actual changes until we run through that full process, APA process.
What I'm saying is whether or not we have a date certain, we have to have this to them.
Yes.
June, by the end of this month.
So I wanted to clarify so people understand. We have to have our job, our baby step done by this date. And you're correct as the other, but so we're on a timeline.
Correct. Yeah, so you guys have June 30th to submit, but we do not know the actual Legislative Commission date or implementation.
No, we need a crystal ball for that.
Okay. Do we have any public comment in the north with regard to Regulation 1?
There's no comment in the north, Chair.
Okay, thank you. And online, do we need to tell people what, how to comment online?
No, Chair, we don't. We've already read the information into the record.
Okay. And we don't have any.
To provide public comment, please click the raise hand icon if joining via Zoom. There's no online comment.
Okay, great. And so with that, we'll go ahead and take a motion for consideration of proposed adoption amendment and or repeal of Regulation 1 of the Nevada Cannabis Compliance Regulations.
Member Mazzarano motions to approve the consideration of proposed adoption, amendment, and/or repeal of the Nevada Cannabis Compliance Regulations, specifically Regulation 1, issuance of regulations, instruction, and definitions.
Thank you. Do we have a second?
Douglas, for the record, I'll second.
Okay, we have a first and a second. Any discussion? Hearing none, all those in favor say aye.
Aye.
Motion passes. Okay, moving on to Regulation 4, Mr. Miles.
So we have Regulation 4. These changes expand the categories of violations, clarify infractions, and update the regulation to align with various statutory changes. 4.010 adds appropriate reference to NRS 233B pursuant to Senate Bill 328. 4.020 explains the dates used for progressive discipline, and those dates will be based on the statement of deficiency dates. 4.030 limits the civil penalty amount and adds in regulation mitigating circumstances pursuant to Senate Bill 195. 4.033 through 4.061 expands the categories of violations to 7 categories from the initial 5, wherein category 1 now is limited to only revocable offenses, and category 7 is minor infractions that won't result in revocation and can only result in a possible suspension after 7 different violations. Civil penalty amounts have been adjusted and various infractions have been clarified and shifted around. One important note is new inventory control. Now the violations on the inventory will be based on a percentage of that inventory rather than just a straight count. And that is also the same for tagging the plants. 4.070, 4.090, 4.095, 4.100, 4.105, 4.110, 4.130, 4.135, 4.140, and 4.145 were all just very minor, mostly housekeeping updates, some to include language from the various statutory updates. 4.137 is the additions of settlement into the regulations. 4.150 is the addition of a reg for a petition for exemption from excluded felony offenses pursuant to SB 277, which we already do, and I believe we have a couple of them on agenda today, but this is the actual regulation. Right now, we are following a procedure we created from Senate Bill 277 until these regulations were adopted. And 4.200, actions related to unlicensed activity pursuant to Senate Bill 328, wherein we can fine illicit enterprises up to $50,000 for their illicit activity. That is back to you, Chair.
Okay, thank you very much. Do we have public comment on proposed Regulation 4? You could just come up and state your name for the record.
Yes, good morning, or maybe afternoon, still morning. For the record, my name is Abby Kaufman. I am the Secretary and new Executive Director for the Chamber of Cannabis, the state's largest industry trade association. And first of all, we're really encouraged by the CCB's incorporation of industry input, really appreciative of Chief Concrete and Deputy Director Miles over this workshop process. We also acknowledge that there's still plenty of work to be done, and understand that there are limitations to the CCB's authority and some areas of concern with agent card costs, packaging limits, allocating funds from enforcement actions, consumption VAP, venue dynamics may require legislative action, but I hope that the CCB will continue pursuing these areas as they are, as it is within their authority to. For Regulation 4, and I know that most of this has already been expressed, so just one thing that was not included in our initial committee comment during the workshop. But as you may be aware, the Chamber of Cannabis, we spearheaded the efforts to pass the provisions in Section 4.5 of SB 277 to establish the pathway for ex-offenders to obtain a cannabis establishment agent card. And broadly speaking, and absent of any clear and certain threats to public health and safety, it's the opinion of our organization that any individual who has served their time and paid their debts to society, as prescribed by the courts and law enforcement agencies, should not be prohibited from obtaining an agent card. So most of the hearings on NCC 4, or the petition hearings so far have been closed, and it appears that the first open, and it seems that those did not involve any limitations based on the one open one. There were questions during the April board meeting about what limitations could be ascribed by the board. So that causes me to believe that having those limitations and restrictions is more of the exception than the rule. And unlike the guidance that's currently posted on the CCB website for the petition process, Reg 4.150 requires the petitioner to, in order to submit the petition, in item 3, subsection 8, a list of conditions and limitations that they're willing to accept on his or her involvement in the cannabis industry. And that just seems a little bit, to have require a petitioner to list out what they're willing to give up in order to even submit the petition seems a little like unfairly prejudicial and like pessimistic. And also that paragraph is misaligned with the intention of the legislation. And so rather than forcing petitioners to provide a list of limitations in such an open-ended manner as part of the initial application, it'd be reasonable to add that, to just strike that, or have that be one of the things that the board is able to request as part of their investigation of the petition, rather than in that initial application. And I don't know if that's possible or if there's any initial feedback with that. For this section, is there engagement allowed with the public comments? Like, or no?
Not,
okay.
That's not the norm.
Okay, thank you, sorry. And then, okay, so lastly, for 4.145, in closer reading, it does appear that's one about petitions for changing regulations. In rereading the full language, it does seem that you can request a waiver for the filing fee and the filing of a brief, assuming that is the correct interpretation. And a waiver can be requested. It'd be nice if those instructions were included with the instructions on the CCB website. I shared this, but past the deadline. So for writing, if you'd like to review it later. Generally, just the use of word timely in several of the fours is a little still ambiguous, but other than that, like I mentioned, we're really appreciative of the workshop opportunities and know that I'm hopeful that these changes will continue after the June 30th deadline for submitting all these changes until the next one. So,
and if you could submit your comments, that would be great.
Yes, this was submitted. This one was delayed. Normally I do it in advance, but I sent this morning.
Oh, okay. Thank you very
and
much.
Link to all of our workshop comments as well, which we also stand behind in that doc. So,
okay.
Thank
Appreciate
you.
it. Thank you.
Hi, good morning. Lake Martin on behalf of Nevada Cannabis Association. I wanted to thank Deputy Director Miles for reaching out to the industry and incorporating comments early on and working on the changes to Regulation 4. Very much appreciated. And we're supportive certainly of the addition of 4.200 and the efforts to increase administrative enforcement of the unlicensed cannabis activity. I had one small potential change, if it's possible, that I wanted to get on the record, which is 4.035-2A2 and the similar provisions where it requires the second or subsequent violation in the immediately preceding 3 years. The penalty is a civil penalty of not more than $20,000 or not more than 30 days. Our recommendation is to change that small change to and/or, allowing the board more flexibility whether to, depending on the nature of the the nature of the violation, to allow it to be either 20,000 or a suspension. And there are 4 similar provisions like that. So it's 4.035-2A2, 4.040-2A3, 4.050-2A4, and 4.055-2A5. No changes to 4.060 and 4.061 because they do include the and or opportunity for suspension. So it's just the recommendation that that be carried through to the other sections.
Okay, thank you.
Thank you.
Any additional comments for regulation 4 in the South?
Good morning. My name is Derek Connor with the law firm of Connor and Connor. I'm commenting on regulation, really my biggest issue. And I do appreciate the work of staff and everyone that went into these workshops. I do not love the final work product. Discipline has expanded under these new regs, or under these draft new regs, and the due process standards seem to have retracted. We don't have the ability to subpoena your file. We don't have the ability to take depositions of witnesses. And we don't have the ability to do written discovery. Now, there's some litigators up here that are on the board. I think you would understand how difficult it would be to try to maintain a case with those restrictions. I think the public deserves better. And I think that these regs need to be fixed so that we would be allowed the ability to at least take depositions, to maintain testimony. People move, people die, people change jobs. And without that ability, we can't even have that ordered by the ALJ in these under these draft regs. So those are my comments, and I'm sure we'll be discussing this again. Thank you.
Thank you,
I
Mr.
apologize for my voice. I was out sick for a week. Normally, it's very convincing.
And Mr. Connor, just so you know, with my experience working with the LCB reg writers, I have a feeling that it's going to look completely different than what we're submitting, but we'll just go with the process and see what happens. But they take their job very seriously, and they will really take our regulations and give it a workup for sure.
I appreciate that.
So I don't think this is the last.
And the chair, or Honorable Douglas made a comment earlier about public perception. And I think if the public sees the things like these people are taking fines for $40,000 for, not having paper towels or whatever, I think the public would be surprised to see the reason a lot of people do that is because they're afraid of their ability to have a fair fight in front of the CCB under these types of situations where we don't get any discovery. And, we have a limitation in witnesses. The amount of time we can actually take to try to, go to these administrative hearings it's difficult. And I think that, again, the public would, be happy to know that the state is not hiding behind itself and it's being open with its citizens and it's giving us an opportunity to defend ourselves.
Mr. Connor, Douglas for the record, I take exception. I'm tired of getting us bashed that everybody's afraid and they're running like hell. Folks speak up when they want to. You spoke up at the legislature, changes got made. We're not ogres, we're not bears. When your clients don't do what they're supposed to do, this is a business, this is professionalism. Probably 90% of folks in the industry do what they are expected to do. We have a very small percentage that don't do it. I personally, but the regulations are what they are, the changes, because the legislature mandated, we are a creature of the statute. We have to abide by that. But the progressive discipline of slapping people on the wrist, sometimes when they intentionally disregard the regs and make business decisions, not public decisions based upon the public good, it is a concern. That's why we have these bodies. That's why things got changed at the legislature, perception of the need for change. So this is a work in progress. And I applaud the changes you're recommending, but I need that comment today that, no, I don't see people who were afraid to come forward, especially when they negotiated. We didn't ask them to pay the big sums. They put that up there. So that is just kind of something that sticks in the craw because we've been crucified before the legislature. We've been crucified in the press. Oh, that we beat on people and they don't want to come. So that's my 2 cents. But I appreciate the changes you're recommending this day for fairness.
Thank you.
Thanks.
Okay. Any other comments on regulation 4 in the South? What about the North?
No comment in the North.
Okay, we'll go online.
There's no online comment.
Okay, with that, I'll go ahead and take a motion for the approval of.
Madam Chair,
Yes.
before we go ahead and probably approve this, Mr. Miles, just in terms of what we have before us and the changes, are they primarily incorporating as required what's been passed by the legislature?
Yes, they have. Actually, when he spoke before, depositions were literally taken out by the legislature. That's the reason it was taken out of the regulations.
Thank you.
And again, as administrative hearings, we've never had, at least as far as the administrative hearings I've been involved in, they haven't been discovery. There's been turnover, what you're going to submit, they turn over what they're going to submit, and you move forward with the process.
The only one that I know of, there was a lot of discovery. A lot of discovery, so, okay.
I think that depositions were allowed under that one because it was under a prior statute. But I don't think any were actually taken. But they were allowed at that point, and then the statute changed in 2021.
I've been deposed quite a few times.
Okay. Does that answer your question?
It answers, clarifies for the record what's going on.
Okay. Any additional? Yes.
Can I ask a couple questions? Member Durrett, for the record, I as far as the due process provisions, I would be open to having a further discussion on that and expanding them, but I just don't think we'll have the capacity to do that today. And I think it's something that perhaps could be discussed at the legislature. I also wasn't aware of the concerns about it. I mean, there have been discussions in the past, but I think it would have been helpful to have comment on that earlier. But it's not like I wasn't aware that that was an issue, but I would be supportive of figuring out exactly where we should be to be in line with other agencies and expectations. So I did have two specific questions before we move on. One, under the comment from the NCA about changing it to an and or, I would be supportive of that to give the board the discretion. Is there the possibility to change that today? And then I have one question after that.
Just to add, if the board is inclined to make that edit, good. If not, I don't think it's, there's no.
Well, and that's, I mean, that's up to the board. I was not inclined to make any changes today. I was going to just send this over to LCB and let them work with them because, again, we'll be back to where we were last meeting. And so we're under a time crunch, unfortunately, but it's not the end of the road. This is something that is going to keep going, and changes will be made and can be made, and petitions or not petitions, not legal petitions, but recommendations or requests can be done of LCB for these changes. But I, it's not just my vote, it's everybody's vote, democratic system. So yeah, whatever the board, whatever is the pleasure of the board.
Member Douglas, for the record, Mr. Miles, you seem to have another comment.
The and/or was put in multiple times. Let's look, example is 4.0 40. Or actually a better one is 4.050. Again, you have basically multiple times that you can do and or. A lot of times you can just do a fine. Gets to a certain point where you do a suspension, you can do a fine or a suspension. Then when it gets much later, like when you've had 3, 4, 5 violations, depending on what it is, then it's a fine and suspension. That's how that ended up. It's not like every one of these is a fine and suspension. It takes a long while to get to it before you get a fine and suspension. So it's multiple offenses before you even get to that point. That's why it was left in there. That's why there's and ors, and then there's just some that are just ands.
That's the difference.
Thank you.
Yeah. And again, also with the suspension, you could also do a fine and suspend for 1 day. You still have the jurisdiction to decide how long the suspension's for.
Okay, Member Durrett, I have another question. The comments about listing the conditions to get a waiver under SB 277 of a conviction. I didn't quite understand that. I think I support all the regs that are being proposed today related to that, but I think the comment was that on the website, you are asked to proactively list the conditions you would accept. Is that correct? It doesn't seem like we would ask for that. And if it's just advising people that they may be subject to conditions, that makes sense. But it's not asking for a list of conditions that the petitioner would accept, right?
Is that in our regulations? That's not the regulations. I think that was our website. Or is that the
Right.
regulation?
Yeah. Yeah.
Oh.
It's on the
Website, I
website.
believe it's also in the regulations. We put in there for simple issues, and we don't expect them to fill out very often, but let's say guy has a long history of money laundering and he wants to put in there as a condition that, won't handle money in any way, shape or form while I work at this facility. Things like that. That's all it is.
Yeah.
I think that's must.
Yeah.
The statute says you could put conditions on it, so the board needs to have some kind of idea what they'd be willing to accept.
Exactly.
Yeah.
That's all
Member
we put in.
Durrett, yeah, I'll ask about that about that later because it is just the website. I think it's I can see how that would be.
It is the regulation. It is the proposed regulations.
To ask them
my mistake.
about conditions or just
the conditions. It's the regulation and website.
to ask them to proactively list what conditions they would agree to?
Yes.
Oh, okay. All right. Thank you.
Okay. All right. Any additional questions before we move to a motion for approval?
Member Mazzarano motions to approve the regulation, disciplinary and other proceedings before the board as listed in CRs 1 through 24.
Just for the record, second.
Okay, we have a first and a second. Any discussion on the motion? Hearing none, all those in favor say aye. Aye. Any opposed? Motion carries. Okay, we'll go on to regulation 5 again. Mr. Miles?
Regulation 5.075 just clarifies in reg that the CCB inspects each establishment or may inspect each establishment once a year, and the labs will be inspected at least once every 2 years. That's the only modification to it.
Thank you. Any questions for staff? Okay. Prepared for a motion?
Comment.
I mean, a public comment, I'm sorry. Public comment in the South with regard to, this is proposed regulation 5. Thank you. Okay, no comment in the South. Any comment in the North?
There's no comment in the north.
Any comment online?
We have online comment. Catrice Saunders, go ahead.
Mr. Saunders, go
Hi
ahead.
there. Hi, this is Catrice. Hi, this is Catrice Saunders for Public Record. I'm a longtime patient advocate, and I've been affected traumatically by the war on drugs at a state level, at a federal level. In regards to SB 277, just looking for some clarification because I have to fill out my petition on what is required for the extra steps I have to jump through after helping build the industry for the state of Nevada, helping local business owners with hundreds of millions of dollars. I find myself still having to navigate through this late date in regards to my federal cannabis conviction for helping the lovely patients of Nevada and helping build the industry of what it is today, which is a nightmare. You guys pass rules and regulations when needed to get things passed through for your friends and family, but through people who have helped build the industry, we have to jump through extra hoops. I know there's other people that have extensive criminal backgrounds. I, however, do not. I helped build the cannabis industry, and I shouldn't have to jump through all these extra hoops to just fill out a form to get back to working. After I helped the state of Nevada build revenue and local business owners, I've had to spend time away from my family. It's been destroyed, while white privilege gets a pass to write rules and regulations to help further their generational wealth. I'm still having to struggle to put my life back in order. With that being said, I was just looking for clarification on why there needs to be a closed process in this and why it's not open to the public. And having myself and others affected by the war on drugs should be involved in anything moving forward that has to do with retroactive harm that has been done to myself and others. And then I'm driving right now, so I can't pull up the particular number of the registration. I just wanted to know that it will be listed that the medicine has been used, or you guys are using radiation for remediation because no one's growing properly, and everyone wants to hide the fact that there's mold and pesticides being used in the legal industry. I know Las Vegas Weekly the other day put an article about pesticides being in legal grows, and I know that's happening also in Las Vegas. You guys just try to keep it under wraps so that you guys can have the special interest of your business owners at hand, and never mind the public health that is not being taken into consideration by these business practices that are being used, not being labeled. The public needs to know that their plants are being radiated, and that's why there's poor quality, and that's why things are not selling properly, and the black market is thriving because no one wants to buy medicine that has been radiated, let alone not even marked, because you guys are trying to help people's bottom line, which is also criminal. Okay. So I was just looking for clarification on those two things. And I'll be at the meeting on 28th in person. Thank you so much for your time today.
Okay, thank you. All right. Thank you. Any additional public comment online?
There is no additional comment.
Thank you. Okay, we'll bring it back to the board then for a motion with regard to this regulation.
Member Mazzarano, motion to approve Regulation 5, licensing, background checks, and registration cards as indicated NCCR 5.075.
Okay, we have a motion. Do we have a second?
Just for the record, I'll second.
Any discussion on the motion? Hearing none, all those in favor say aye. 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 Any opposed? Okay, motion carries. Next, we'll go to item D, which is Regulation 6. Mr. Miles.
Regulation 6.025 updates the time and effort regulation pursuant to the changes required in SB 195, and also includes the hourly amount charge, which I believe has been charged since Health and Human Services days. Regulation 6.085 updates the notice section when security equipment has malfunctioned.
Thank you. And with that, we'll go to public comment. Any public comment in the South with regard to Regulation 6? Hearing none, any comment in the North?
No comment in the North.
Okay, what about online?
There's no online comment.
Thank you. With that, bring it back to the board for a motion, discussion, and a vote.
Member Mazzarano motions to approve Regulation 6, production and distribution of cannabis, NCCR 6.025 and NCCR 6.085.
First, is there a second?
For the record, Douglas seconds this motion for approval.
First and second, any discussion? Hearing none, all those in favor say aye. 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 No opposition, motion carries. Okay, moving on to Regulation 7, Ms. Cronkite.
Good morning, Chair and members of the board. Chief Cronkite for the record. NCCR 7.035 has proposed changes that require a sales facility to provide a copy of the certificate of analysis to the consumer upon request. This could be electronically or in any other medium as desired. Additionally, some language is stricken just as cleanup. And also the correct statute in subsection 6 was referenced for an Nevada Department of Agriculture based on public comment received during the workshop. I'll turn it back to you, Chair.
Thank you. Okay, we'll go to public comment with regard to Regulation 7. Do we have any public comment in the South with regard to cannabis sales facility? Regulation 7. Seeing none, we'll go to the North. Any public comment on Reg 7?
There's no comment in the North, Chair.
Okay, and online, any public comment online?
There's no comment online.
Bring it back to the board. Any motion on Reg 9?
Yep, Member Mazzarano motions to approve Regulation 7, Cannabis Sales Facility, NCCR 7.035.
We have a second.
Douglas, for the record, I second that motion.
First and a second, any discussion on the motion? Hearing none, all those in favor say aye. Aye. Any opposed? Any opposed? Okay, motion carries. Thank you. We'll go on to Regulation 11. And, right.
All right, Kara Cronkite for the record. NCCR 11.010 makes changes to requirements for the scientific director, allowing an interim director and their duties. Scientific director's residence was changed from Nevada to within 200 miles as requested by laboratory representatives. This is a 200-mile radius. The intention was to capture all existing scientific directors. However, based on public comment received this morning, I believe that one may have been inadvertently not included. So if there was a recommendation to increase this mileage or to allow for a waiver and approval of the board to exceed this distance, I think that would be acceptable by the staff. Additionally, based on feedback received, we revised the proposed 60 days in subsection 3 back to 90 for interim directors and revised the 72-hour time frame in subsection 4 to 3 business days and changed subsection 6 back to 90 days. This was all requested during the last workshop. There was also a request during this recent public comment to restart the ILAC committee, but I just want to let the board know that I do think that that could be accomplished under the Cannabis Advisory Commission as a subcommittee. And CCR 11.015 adds requirements for a safety program. Subsection 4 was changed to state follows the OSHA requirements based on feedback from the public. And CCR 11.020 now includes a timeline to provide the board agents with a copy of the ISO final inspection report. And CCR 11.025 clarifies specific references, standards, practices, and procedures that laboratories are currently using. We're just updating information and making it more clear. I would like to point out that the references in subsections 6, 7, and 8 can be used when AOAC standard method is not available or does not fully speak to the process. They do not all have to be followed at once. Using any of these as applicable is acceptable until AOAC standard methods are developed. Based on feedback received, subsection 1B accreditation requirement was removed and subsection G was added to specify that we will issue guidance if there are any conflicts between references. In subsection 6, we added when available and approved by the appropriate board agent. And in 6A, we added the same and additional guidance will be issued as needed. We also removed the reference to BOTEC in subsection 8H. And finally, it was originally proposed to update the reference to the 2017 version of the AOAC guidelines to ISO 17025 document. Since then, the 2024 version has been published, and we're proposing updating the standard to the new version. NCCR 11.030 clarifies sample collection requirements, which are already standard practice in laboratory settings. Based on public comment from the workshop, we added some clarification for metric tags in subsection 2 and changed condition in subsection 4 to description. NCCR 11.045 clarifies the font requirements, delivery method, and other changes for R&D testing, as well as creating a potential pathway for variances on research and development testing requirements. NCCR 11.050 gives a timeline for the validity of results posted on certificates of analysis as noted on as a notice on the COA rather than stating it expires as previously written. We've also created an optional limited scope testing option. Sorry, we've also created an option for limited scope testing option for usable cannabis destined for extraction. Remove some testing requirements for wet cannabis destined for extraction. And remove total coliform from usable cannabis testing since it is redundant, as we already test for the more specific categories of concern within the scope of coliforms. The sample collection size was also increased to 20 grams to create a representative sample. Based on public comment received during the workshop, we revised subsection 7 to allow for an extension of the 2-day limit and removed the requirement to share with the facility within 2 days. There was also public comment received today regarding pathogenic E. coli, including the 6 stuck species. And I just want to point out that pathogenic E. coli does include the top 6 shigatoxin producing species, as well as 0157H7. NCCR 11.053 is a new section which clarifies the requirements for instrument calibration and quality control. Based on feedback from the workshop, this section was changed from instrument calibration to testing methods and is now more general language. 11.060 makes some changes to homogeneity testing for edibles. 11.065 has been revised to clarify the requirements for pesticide residue analysis. Based on feedback from the workshop, subsection 3 requires the board to publish a policy on limits of detection for pesticides. NCCR 11.070 specifies aseptic sampling requirements for the laboratory, which is standard practice, and updates testing results reporting mechanisms. Based on feedback from the workshop, 1B3 was added to specify requirements for hand washing sinks. 1C was added to require labs to be notified if a sample was remediated. Subsection 4 was reverted back to original language. 9C and D were removed. The 9C and D, we removed the language about preserving the COAs, as they're already captured in our metric C2cell tracking system. And 9D1 was added stating that the facility must provide retest approval to the laboratory. NCCR 11.075 outlines requirements for remediation, treatment, and retesting of cannabis. And finally, NCCR 11.085 clarifies responsibility of cost for screening and testing. With that, Chair, I'll turn it back to you for public comment on NCCR 11.
Okay, with that, we'll go ahead and do public comment in the South on proposed regulation 11. Morning. Seems like we've been here forever.
Good morning.
Good morning.
My name is Kimberly Ashton. I'm with the law firm of Levinson. Thank you for having me appear this morning or allowing me to appear. As noted by Chief Cronkite, I did submit a public comment. These were consistent with the public comment that were submitted in September of 2023, initial workshop. Based on your comments, Chair, I will not reiterate in detail the specifics of those, but I will say I appreciate the recognition of the importance of ILAC. And I would draw for your attention specifically the language that is proposed under Regulation 11.053. And it talks about a policy. Well, that policy is what a regulation should be. And it should be it's vetted and the industry is aware of it and we know what to follow. But to say that you may develop a policy that sounds like the industry will get a listserv notice saying this is what you need to do without the opportunity for input. And that's what ILAC was designed to do. It was designed specifically to have academic specialists, agricultural specialists, and other experts with respect to organic products come together along with the industry and talk about the respective testing standards. And so for those reasons, I would strongly encourage this body to reinstate ILAC based on the fact that I believe it would give you, again, objective scientific standards in which you can rely on in order to promulgate further regulations and testing standards for the industry. The other question, or the other specific matter that was raised by the Citizens for Public Safety Alliance was the request to modify Regulation 11.085, which requires the licensees, specifically the testing labs, to hand over the certificates of analysis to both the licensee as well as to the board upon completion of the scientific lab testing. As we've noted before, and you've heard extensive testimony, the labs are not getting paid. And so as a result of that, what we're requesting is that there be an amendment to that regulation that allows the laboratories to hold on to that certificate of analysis before releasing it to the cultivator, who then can release it to the dispensary and sell the product. Don't mind turning it in to the state because of the fact that it demonstrates that the testing has been completed. But to ask the laboratories to hand over their results without payment, I would respectfully submit is inconsistent with what is intended by your regulations. And also it's inconsistent with your other regulations. You specifically have a regulation that states that labs that were selected by the CCB for retesting shall be paid. So it's a guaranteed payment in that aspect, but for the lab performing the same function on behalf of a licensee, there's no requirement for payment. And so for those reasons, again, I would note the fact that there is an inconsistency in the regulations, and there is a financial hardship that one group of your licensees are experiencing that needs to be addressed. And so it's a simple modification and ask that you consider that. The other comment that was raised was specifically submitted by Let Us Test, LTL, and as noted by Chief Cronkite, this pertains to the distance restriction relative to the scientific lab director. I would note to date that there has been no statement by staff or of a legitimate government interest in this matter or the need for it. As you know, government action with respect to dictating private employment practices is one in which you must have a reasonably identifiable legitimate government interest. There's been that's never been articulated. And in fact, the comment was today that it was requested by other lab companies or by other members of the lab industry. I would respectfully submit to you that that's clearly anti-competitive because it only applies to one. I'd also state that based on that comment, it's clear that this is not a regulation of general applicability, and therefore it fails the statutory requirements under 233B. So for those reasons, I would respectfully request that you consider striking the language relative to the distance requirement. If there are specific obligations that a scientific lab director needs to meet, those can be articulated and followed. But simply because of the fact that the lab director chooses to live in Tahoe and work in Las Vegas should not otherwise preclude him from being a scientific lab director in Nevada. And with that, as always, I'm happy to answer any questions and appreciate the opportunity to provide public comment to you. Thank you very much.
Hi.
Good morning. Alicia Ashcraft, a law firm of Ashcraft and Barr. Adam Fulton, myself, and Ms. Rushton submitted comments. Several of the workshops appeared, and Mr. Fulton couldn't be here today, so I'm carrying the oar for both of us. And we'd first and foremost like to thank Chief Cronkite and all of the lab staff and auditors and inspectors. They worked very hard. They were incredibly generous with their time in meeting with us a few times. And so I'm so grateful for the work that they have put in. One of the things that we asked early on was for the goals or the issues or the problems that we were trying to solve for in developing these regulations. It's real hard to give comments if you don't know what target you're trying to hit. And you also don't have a measuring stick afterwards to know whether you were successful in the regulation that was developed and applied. The answer that we got back was that these changes to the lab regulations were needed because the industry was asking for clarity. And for context, I just want to, for your consideration, explain the request for clarity that I'm hearing from several of the labs, some of my clients, some others. And that is that, and you've seen, there are a plethora of guidelines and standards that are made applicable through the regulations. And it is intended that the labs, through their scientific director, use their education, their degree, their certifications to make educated decisions within a range of choices of what should apply in a certain circumstance. But what is happening is that oftentimes, although they choose within a range, they are told that their choice is incorrect. To put this in kind of an analogous situation, and I'll not really pick on Dr. Mazzarano, but if you are a doctor who has been educated, licensed, certified, and you are told that a particular prescription drug is perhaps necessary under certain conditions or certain mannerisms that a patient is exhibiting, you as the professional then in your assessments, in your testing of that patient need to determine if that's appropriate in that circumstance. And you decide within the range of guidelines that you are given, but then you are told repeatedly you chose wrong or that wasn't best practices. And that's somewhat of what the labs are experiencing. They're making decisions, they're well within guidelines, but still being told that it's incorrect. And I'm not sure the board members are aware, but oftentimes their inspections and audits are longer than just about any other facility. It is not uncommon for them to be inspected and audited and then have follow-ups over the better part of a year before receiving a statement of deficiency. It is not uncommon to get a statement of deficiency more than a year after an inspection takes place. Well, their procedures could have changed by then. If there was something wrong, the person that was creating that situation could have been terminated or left. So it's incredibly hard. I don't know, even with the work, I think there's more work to be done. But I'm not sure that the regulations, the proposed regulations as presented, really achieve the goal of providing clarity. There is certainly more stuff. I don't know that it will help the labs find clarity in what professional choices they can make within a range of acceptable guidelines. I don't know if ILAC is the answer. It had some issues I don't think anyone would deny previously, but I think it's certainly a step in the right directions because these are very technical requirements. To make a seemingly small change can have a large financial impact in a lab. Equipment and testing and changes and pivots in policy and procedure and training of the lab techs is incredibly expensive in a segment of this industry that is already so hard hit for the reasons Ms. Rushton brought up. So I, again, just bring for your consideration, do the proposed regs really achieve the overall goal of providing clarity for the independent testing laboratories? I'm not sure. It is going to be more onerous for them. It is going to be more expensive. So just please be aware of that. Other quick comments, and I'll somewhat ditto Ms. Rushton.
Interrupt you
Yes.
just because I have to go at this point. I would support Ms. Cronkite's changes that she talked about. I'm not going to be here for the vote. I have a family emergency I need to attend to. As the comment, having gone to some national things over the last couple of years, we are beginning as a cannabis regulator and regulators to look at national tendencies. And as you said, this is a difficult thing to figure out. Each region is kind of on their own. There's some unanimity. But yeah, it's going boo in the night. And as you said, trying to hit the moving target if you don't know what the target is. So until it gets out there and beginning today, putting something out, it will get massaged again at the next level. But having the public record made today that can go up is very important. So I appreciate the comments. I have to go and step personal on this one, even though it's a difficult subject. No, these are just
But just circling back on those two items that Ms. Rushton mentioned, I just want to elaborate a little bit further on NCCR 11.010. The original, and Chief Cronkite can correct me if I'm wrong, the original proposed regulations stated that the executive director had to be a Nevada resident. And there was a lot of pushback on that because Nevada is still not the most populous of states that we would be cutting off potential really qualified scientific directors in a global world where there's telemedicine, there could be telescientific directors. So that was the comment back that then got changed to 200-mile radius. And the question that we had was, again, what problem are we solving for? And I think the comment, correct me if I'm wrong, is that CCD staff did not feel that the scientific director was spending enough time or was not being involved enough in the lab operations. And my comment back was, well, then let's draft regulations for that goal. I don't know that a residency requirement or a residential address within a certain mile radius solves that issue. You could live next door to the lab and not be involved. You could live in Finland and be very involved. I don't know that this solves for the concern. So I would actually ask that it be stricken altogether, and then come back and let's find some proposed regulations that maybe address the issue a little more closely. The other one that Ms. Rushton mentioned, and I would like to as well, is NCCR 11.053. This is the statement that there will be policies and testing methods that will be developed. I would just caution that this not be used for, and again, I mean no offense when I say this, for ad hoc rulemaking and regulation making. I just don't want it, as Ms. Rushton mentioned, to circumvent the process that's very important in the promulgation of regulations. Hearing people in workshops, maybe they don't fully understand it the first time and they need to hear it the second time before they are prepared to make a meaningful comment. That's very important. And when given, again, the costs of changes that so highly impact laboratories, making changes that may seem small in policies and testing methods have a big impact. So I'm very concerned about how that will play out when applied to the labs. Thank you so much for your time and consideration.
Thank you. And we'll let the record reflect then that Justice Douglas had to leave. Okay, so any additional comment in the South with regard to Regulation 11? Any comment in the North?
There's no comment in the North, Chair.
Okay, any comment online?
If you wish to provide public comment, dial *9 to raise your hand if joining by phone, or click the raise hand icon if joining via Zoom. There's no online comment.
Okay, great. Yes.
If you don't mind, Chief Cronkite would like to speak to some of the comments because these were actually very important points that were made and she'd like to respond.
Yes.
Thanks so much.
Thank you. And then we'll go to a vote.
Okay, Kara Cronkite for the record. I do want to point out that in 11.050 subsection 7, the requirement to provide the results to the facility within 2 business days was removed. So if it's somewhere else, please let me know, but that was stricken for the payment issue. For 11.053, it was requested by labs that we set a limited detection for these pesticides because some are lower than others. And then there was concern that one lab would fail the results for a pesticide, whereas another lab would pass it and they would both be in compliance. We agree that there should be an LOD. However, we didn't have time to draft that language in regulation. And that's why we thought it would be a good balance to allow for the CCB to draft a policy on how to determine the limited detection. So that's why that's in there, just as for some context. And then regarding the distance requirement, the problem that we were trying to solve for that one was that the director of the laboratory is supposed to be the person who's training, guiding, monitoring all these actions taking place in the laboratory, and that they should really be readily available in case of emergency. If that distance is expanded or if there's a waiver granted or anything else, I would support that. But that was the intention. It wasn't just that they're involved. It is that they're readily available in case of an emergency or need to be on site to monitor staff or anything like that. So just clarification. Thank you.
Thank you. Okay. Yes.
You're about to break for lunch.
Do you want to come up here and state for the record your name?
My name is Steve Adamson.
Okay.
I live in Panaca, Nevada. And my son behind me, Trevor Adamson, we thought he was going to be on the agenda because he was denied the marijuana work card.
Okay.
And he had several letters of recommendation. In Caliani, where this facility is, Sean Fitzsimons is on the city council.
Okay.
And he also teaches at the high school. I taught for 30 years and I'm custodian there. And he wrote some letters of recommendation. And we were just wondering if you're going to lunch, if we can come. We came for 165 miles so that
Yes.
he could be on this, in this
And
meeting.
we're not going to break for lunch.
Okay.
If anything, we'll just break for a few minutes.
Okay. I just want to make sure that Trevor Adamson gets.
Yes.
Is he on the agenda?
Yes, absolutely. We just, what we did is we put them last. So
Okay.
then that way, because we go into closed meeting. And so we wanted to just give them that opportunity to do that by themselves.
Okay.
Okay, instead of opening and closing and opening and
With him,
closing.
he did not understand what open and closed meeting is. I do, but he's not opposed to an open meeting status.
Okay, and we can talk about that as soon as we wrap up this item and we're almost done.
Okay,
Thank you for your patience. Okay. Okay. So on regulation 11, do we have any additional comment? Okay. And with that, I think we've been through.
Open up to the board for comment.
Okay, so yeah, we went through and did the public comment. I totally lost track of where we were. Okay. All right, so now we're back for a motion or any discussion on these items, hearing what the public comment and staff has to say.
Member Mazzarano just wants to reiterate what Chairman has said, is that whatever is approved today will be looked at nauseam by the LCB. So I think it's important that we take this baby step and move things forward and let the LCB change some of the things that people have concerns about if they feel it necessary.
Yes, and we have in the record, all the comments are on the record to take up, just like we mentioned before. And so I appreciate all the comments. And with that, I'll take a motion.
I'm the only one left here. So Member Mazzarano, motion to approve Regulation 11, Cannabis Independent Testing Laboratory, NCCR's listed 1 through 13.
Okay, and I can second that motion. I'll second the motion. Any discussion on the motion? Okay, hearing none. All those in favor say aye. Aye.
Aye.
Aye. Any opposed? Nay, motion carries. Okay, and that concludes then our regulation agenda, and then now we'll go back. We're gonna take a quick, like 1 minute break so that we can explain the process, but now we're gonna go into our petitions and go into closed meeting as soon as we.
As a reminder.
Yes.
The petitioner has to request the closed session.
Okay. And there might be a. Okay. Thank you. Okay, so we've got item 8. This is the petition filed pursuant to Senate Bill 277. And we have, but we're gonna take a minute and then we'll come back and then who will we take care of first?
Trevor Adams is there.
Okay, Trevor Adams will be first. So we'll be back in about 2 minutes.
Takes time.
We'll be patient right there.
Again, hi. I just want to introduce myself.
Hi.
I'm Dr. Bruce Burnett.
Oh, hi.
I'm a lab owner. Many of the board members, including the director, have had the opportunity to tour the laboratory. If you've
Oh, okay.
not ever been in a cannabis laboratory, you're welcome anytime.
What's the name of your lab?
Ace Analytical Laboratory.
Oh.
In fact, I think pretty much most board members
internet. So it's it's your decision.
It doesn't matter, honestly, it's okay. Everybody should hide my password.
You have to tell us what you want. I can't make that decision for you. So you talk to your dad, no, you're his mentor or friend. You are his dad. Okay. Talk to dad and talk to son and you decide, okay? But you gotta do it quickly.
Yeah. I'll sorry, close Jesus. Yeah. Just close. All right, close and be, yeah.
Closing it, okay.
Nobody else needs.
Good job.
Should we shut the door?
Yes.
Would you mind shutting the door over there, please? Finish with this.
We're good to go, okay? All right, we'll go ahead and I'll take a motion for approval of the petition with the condition that we receive a letter from a cannabis employer willing to employ Mr. Adamson. I'll make that a motion.
Member Mazarano seconds that motion.
Okay, we have a first and a second. Any discussion? Hearing none. All those in favor say aye. Aye.
Aye.
No opposition. Motion carries. So it's approved, but it's conditioned on getting that letter in. So if that letter doesn't come in, he's not going to get his card. So he has to get that letter in, okay?
Do you have email response for us?
Hand it to you as soon as you walk around.
There you go. Okay, thank you very much and good luck to you. Okay, all right.
Thank you.
Thank you. Yes, I believe in second chances and yeah, so go to it. Thank you.
I'm calling in.
Calling in there. Okay. So we're gonna have the record reflect that Member Mazarana is going to join us by phone because she is on her way out. So we'll still have a quorum.
I'm here.
It's gonna have one person on the phone, one person on Zoom, and an emergency exit. Okay, we've got this. All right. Now we are basically going on to item 10. This is our briefing from the chair. Oh, no.
Willie George Clore.
Oh, I'm
We have
sorry.
another petition.
We have another petition. Yes, we do. Willie George Clore is our next petitioner, and I believe he's on Zoom or by phone. We're getting that information right now.
And we'll also just need to confirm that member is around this.
Petition.
Amber, Steve, do we know if Mr. Clore is on the phone?
There's someone on the phone. Need to confirm that it's him.
Might be Member Mazarano.
Member Mazarano is on the phone.
Thank you.
Thank you.
Amber, did we get any documentation on this next petition? form of a support letter?
Chair, we have not received one from him. We did request it all, just like Mr. Adams.
Okay, thank you.
So I texted him and then I emailed him to let him know he can rejoin, so just waiting to see if he joins the Zoom.
Okay, thank you.
Which one? Yeah, you could just put on the agenda and you'll have a quorum. Because it's not. We can't get a hold of them, we can. We tried to text him and he's not responding. So I don't know how long we give him to rejoin.
Yeah. Is he supposed to email back or text back? Okay.
I mean, he was earlier. He was emailing me back and forth.
Maybe he had to go to work. Well, I guess we can give it like 5. What do you mean?
Chair, if you'd like, I can give my brief to give him a few more minutes and then we can come back to this agenda
Yeah.
item.
Okay.
So she have to make a motion or can she just move this?
No, the agenda item considered trailed.
Okay.
Yeah, okay, so, well, then we'll trail this to the end. Mr. Willie Floor's petition, we're gonna trail that to the end, and then now we'll go on to item 10, which is the briefing from the chair and executive director. And I don't have anything other than thank you for all your hard work. This has been quite a juggle today, but it's been good. We've been moving, so very happy. Good job for everybody. Okay.
Excellent, thank you. I will keep my briefing brief. Just to start off, wanted to address the agency's language access plan. So per SB 318, from the 2021 session, all state agencies are required to create a language access plan to ensure that limited English proficiency individuals receive meaningful and timely access to government services in their preferred language. The language access plan outlines the CCB's commitment to equity and the agency's responsibility for providing appropriate language access services using internal resources or state-sanctioned resources. After surveying the staff, the assessment is that our interaction with those seeking language accommodation is still limited. We have not received any requests for language accommodations or translation since the implementation of our first language access plan in 2022. In our last plan, we noted our intention to collect data on agent and card applicants' preferred languages. We have included that question, and thus far, less than 0.01% of respondents indicated that they have a preferred language. The other change to this plan is the languages spoken by CCB staff were available to provide services if requested. This plan is posted on our website under today's board meeting materials and is open to public comment for the next 30 days. We also just want to reiterate that per SB 318, we need to have this posted on the website for 30 days. It's already been up for a little while. So we just encourage public comment to that. I will actually kind of kick this back to the board to see if they have any questions about this. Thank you to Sarah in our office. She's the one that helped kind of guide us through this process originally. And then also is the one that is helping us comply with the 2-year update. So I don't know, Chair, if you had any questions for myself or Sarah. We would be happy to answer those. Member Durrett, member Dr. Mazarana, if you guys have any questions, happy to answer those.
I don't have any questions. I look forward to looking at that. Thank you for that. And it's just, one more thing on the list.
Absolutely. So with no questions, then again, I will just kind of reiterate what the chair said. Huge thank you to Deputy Director Miles and Chief Cronkite, as well as the large teams they have behind them that put together these workshops, the public comments, the small business impact surveys, the statements, today kind of next week as well, the last couple board meetings, the culmination of all of that hard work. So I thank you both and your teams. Just could not have done it without you. And we thank you because what you saw presented today was a lot of hard work, a lot of open meetings, a lot of workshops, a lot of small business impact surveys reviewed. So again, I thank you too. And then lastly, Chief Staley, you had a pretty active meeting today. So just wanted to say thank you as always for everything you and Rachel and the rest of the team do. It does not go unnoticed. So again, Chair, we are blessed here at the CCB to have such an incredible team. So I will close with that. Thank you.
Thank you. Okay. All right, let's see. Item 10, then we'll go on to item 11, which is.
He's here.
Oh, he is?
Yep.
Okay, all right. We will go back to item 8. Yes. And we'll find out from Mr. Clore. Welcome, Mr. Clore. Are you online? Hello? Oh, I hear something. Mr. Clore? Do we show that he's online? Okay, maybe he's got his mute button. Is he doing Zoom or doing phone? Okay. Mr. Clore, do you have your mute button on? We can't hear you. Are you there, Mr. Clore? We're having difficulty hearing you. Are you able to text with him? I don't know if he can hear us. We certainly can't hear him.
Chair, we're trying to get a hold of him right now.
Okay.
We'll let you know if we, here, it looks like he did unmute though, maybe.
Is that him? Mr. Clore?
Yeah.
Oh, there you are. Can you speak up?
Hello?
There you are. Can you hear me?
Yeah, I can hear you guys.
Oh, good. Okay, now we can hear you. All right, so whatever you did, just leave it there. Don't change it.
Okay.
Okay, we need to ask you whether you want your session to be in a closed meeting, which means only you and staff and the board members can hear you, or do you want us to open it up to the public, which means everybody, including anybody who's,
Either or is just fine with me.
pardon me?
Either or is just fine with me.
Okay, but you have to make a decision, so you need to tell me closed or open.
Open's fine.
Okay, and you do know that we have your entire record,
Yes.
and we can, and anything, we can talk about any of that.
Yes.
Okay, all right, then we're gonna leave it open.
Yeah.
Okay. Thank you. Why don't you go ahead and start by telling us a little bit about you and what it is that you want to accomplish here today?
Well, I had got the job at Clearwater LLC, and I was there a month, which I was told that my background had passed, and I was thankful for that. Came back a month later that there was a felony on my record, which was 12 plus years ago, and my petition was to get rid of that if possible, to rejoin the company that I was working for. And that's about it. I just doing all I can to get a job, and all that has been in the past, and I don't know how this goes, but I'm not that person anymore, obviously. I could tell you the whole circumstance, but I don't think it's necessary.
No. In Clearwater LLC, you had a job there doing what, and where was your job?
That is Laughlin, Nevada, and it was a maintenance position.
You were in maintenance? Okay.
Yes.
And what kind of a was it a dispensary or?
The grow house.
Oh, it's a grow, I'm sorry, the grow. Okay. And you were, okay, a maintenance person there. Did anybody from Clearwater send something to us saying that they would hire you back if you got clearance?
They were supposed to, and they said as soon as this had passed, and if I was able to get the cannabis card, all my stuff's in their computers. They would rejoin me with the crew.
Okay.
And that's all I know of that. But I have
All right,
stayed in contact with both my managers, and they said, yeah, good. So if something, keep us notified what happens on today. So.
Okay, well, I'm going to open it up to the other board members to ask you any questions that they might have of you. But I
Gotcha.
can tell you that if we were to approve your petition today, we would have to have a letter from that employer or any cannabis employer saying that they're willing to hire you back if you get your card.
Yeah, it shouldn't be a problem. It's just a phone call.
Okay, all right, so I'll go ahead and open it up to the rest of the board members for any questions. Do you have any questions, board members, for Mr. Clore?
Member Drett, a question for staff. Isn't it a 10-year bar on? No, I was thinking it was a 10-year bar on excluded felonies.
Yeah, when I filled out the paperwork, I'm pretty sure exclusively said, have I had a felony in the past 7 years, which I put on there no, because I haven't. So
the requirement is that there's a conviction of one Class A felony or multiple lesser felonies, and they have to be off probation for 10 years before they can be considered.
Yeah, well, I
That's
haven't
the
been
statute.
I haven't been on probation for over that. So
You're saying you've been off probation for more than 10 years, completely
yeah.
off probation.
Yes.
Chief Gilbert? Do we have that information?
I'd have to bring staff up to comment on that.
I guess either way, we could resolve it by the motion being if it's been more than 10 years, it gets automatically reinstated. And then if it has been less than 10 years, he provides a letter by an employer.
Wasn't your arrest in 2015?
I thought it was 2012, but I could be off.
Well, that was for one felony count, obstruction, resistance of executive officer.
Yes.
But then the next one was for 2025.
15.
I mean, 2025, so 2015. One count of dangerous drug, no complaint was filed now. One felony count of drug paraphernalia. And then you pleaded guilty on 3/21 of 16.
Okay.
And then on 2018, it was ordered to serve the remainder of time in the Arizona County Jail. That was in 2018.
Here, I got a little additional information that may be helpful if you would like me to add.
Yes.
On the one felony count of obstruction resisting executive officer, which he was found guilty in 2012. And then through the sentencing, then also on April 5th of 2017, Mr. Clore was sentenced to complete the remainder of the required time incarcerated, which would come into play with that 10-year period that we look at as far as the approval. And then the other felony that came up on his record was from the September 10th of 2015 case for the one felony count of drug paraphernalia and possession. And that one's still under, within the 10 years. I hope that helps.
Yeah, it was a marijuana charge. Back then, it wasn't legal yet.
Okay. Any other questions from board members? Okay, hearing none. Is there a motion?
Member Durrett, I move to approve the waiver with a letter from any cannabis license stating that they are interested and willing to rehire the petitioner.
Okay, just clarification on your motion. Is this a waiver? Is it a waiver procedurally, or is it a?
Waiver the statutory requirements.
I guess that's a legal question. Is it an actual waiver that we're approving, or
I guess a grant approval of the application?
the petition?
Yeah.
Yep.
Contingent on.
Contingent.
Okay.
Okay. Okay. Let me restate that. I move to approve the petition upon the condition that petitioner submit a letter from a potential cannabis licensee that would employ him.
Okay. Is there a second? Is Member Mazzarana on the phone?
She is.
Oh, it says it takes her a little while to unmute it.
You have to star 9 to unmute.
Okay, all right. Once she unmutes, then we'll do the motion. I mean, once we unmute, I'll second your motion. And we can have a discussion and the vote as soon as Dr. Mazzarana is able to talk on her phone. Okay, good. All right, so she's on there. She's just trying. So just bear with us.
Dr. Mazzarana, dial star 6 to unmute.
Member Mazzarana? Member Mazzarana?
Okay, thank you. So we have a first and a second to approve, to grant the petition with that condition of the letter from a cannabis company that will employ Mr. Clore. So any discussion on the motion? Hearing none, all those in favor say aye.
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 Okay, no opposition. Thank you. Motion carries. Great. So that's been approved, Mr. Clore. So just make sure that you get with staff and get a email address or a fax number or something to get those letters in. And as soon as that letter is in, you will get your card, okay?
Okay, and I will get right on that today and try to think of what else to say. I appreciate it.
Good luck to you.
Well, thank you very much, and I will have them email you that, and I guess you guys have to get
Thank
back
you, guys.
to them.
Thank you,
Back to
Dr.
them
Mazzarano.
saying you approved the card, right?
Stay on the phone though. Yes, yes.
Okay.
Chair, can I add some instructions for Mr. Clore?
Sure.
Yeah.
Mr. Clore, Megan Pistoresi, the program officer with the Agent Card Program, will reach out to you if she hasn't already with instructions on what we need, and then we'll get that process for you this afternoon if possible.
Okay.
Or as soon as you get it to us.
Okay.
Thank you.
Thank you very much.
All right, thank you. Okay, next item is item 11. Next meeting date, June 28th. Okay, and then there's no items for future agendas. And we'll do a final public comment in the south first. There is nobody here. Is there? That's a first. Is there anybody in the north?
Same up here, no comment in the north.
Okay, thank you. Anybody online? Is there any public comment online?
There is no one online for public comment.
Perfect. Thank you so much. And with that, we will go ahead and adjourn this meeting.
Chair, can
Can
I add
Yes.
something to future meetings? I just wanted to thank Mike and Kara for all their work on those regulations and everybody that worked on them. I don't really expect you to put on a future agenda, but I waited until everyone was gone on accident. So I'll say it earlier in one of the next meetings. Thanks to them.
Thank you. Have a great rest of your week.
Thanks, everybody, for helping me stay on the phone.
Good job.
Thanks.